Pardon to mention, my lord. Criminal appeal matter file the IF for bail, my lord.
नहीं pattern to mention me lo criminal appeal IA is pending then also can keep
More than 10 years in custody. Hearing.
Supplemental list, item number 1.
Today was to submit the written note of submission along with judgments.
I'm on virtual mode, Miller.
I'll send copy to him. I was looking for him, but I'll send copy to him.
Right, Mr. Manoj Mishra, and senior advocate, filed the written note of submission, which is taken on record. Mr. S.C. Ratha, and counsel appears to virtual mode. Let a copy of the written note of submission be served on Mr. Ratha during course of the day.
I collect.
Unless they
Hearing closed, judgment resolved.
Okay.
Let him serve the copy of the email ID so that I can we can serve.
And I can collect, Miller. I can collect.
He will collect.
Okay, what's okay.
Item number 2.
In this case, I challenge the order of learned tribunal under Annexure 6, page 49, my lord. A relevant portion is page 54, paragraph 12. It is also seen that the respondent had formulated a scheme in terms of the parameters laid down in Uma Devi case and had issued direction to all employees to submit their application for considering their case for regularization. No averments or documents has been placed by the either side to show whether the case of the applicant has been considered or not, since as per the decision of Honorable Apex Court in Uma Devi, the department were directed to consider one-time scheme for regularization of all casual employees working under them and who have completed 10 years of service, and the respondents have formulated such scheme. It would be interest of justice that the respondents should consider the case of the applicant and pass a speaking order to that effect. Accordingly, the OA is disposed of with a direction to respond to consider the case of applicant in terms of the scheme dated 22/8/2019 and communicated that decision to the applicant within a period of 90 days from the date of receipt of copy of this order. Petitioner was engaged in the year 94 as a casual technical helper, my lord. In the he approached the learned tribunal with a prayer to regularize his case, my lord, and other similarly situated persons like the petitioner who has approached the learned tribunal. In their case, they have learned tribunal has directed to regularize their service. Accordingly, petitioner claimed same relief, my lord, but without deciding the fact, learned tribunal has remanded the matter to the authorities to consider his case.
The similarly placed means in the self-same scheme. It was a schematic appointment or a what is that? What is the nature of appointment?
Casual helper, my lord.
Casual helper. What was the advertisement? What was the condition of employment?
In the Doordarshan, my lord.
No. What was the condition of employment? Is it for a particular period?
Particular period, my lord. Since
against sanction post?
Against sanction post. I have given the similar order under Annexure 5, page 38, my lord.
He is also a person appointed along with this.
Prior to that, your lordship kindly say for a moment, page 34. In the year 2019, opposite part number 4 has recommended all these people employees case for temporary status, my lord. Page 34. Here, my lord, my petitioner's name find place at serial number 8, Dhuleswar Das. Similarly situated persons like petitioner, serial number 2, Vijay Kumar Majhi, serial number 4, Ashok Kumar Das, and serial number 7, Pradipta Kumar Das. In their case, learned tribunal has directed to regularize their service. That is Annexure 5, my lord. And this order has been confirmed by this Honorable Court as well as the Honorable Supreme Court, and they have also implemented the order, my lord. Though petitioner is stand in same footing,
And posts are lying vacant?
Posts are lying vacant, my lord.
Posts are lying vacant.
Lying
No
vacant.
further recruitment has taken place.
No, my lord.
Where is the order of the this court
My
and
lord.
also the Honorable Supreme Court,
My lord.
in which you said that the tribunal's order
Has been confirmed.
Yes.
I have not annexed that, my lord. Sorry, my lord. I have not annexed that.
Do one thing, why don't you
Yes.
file with a memo?
Yes.
Those two judgments.
Kindly.
I'll be taken up tomorrow. I'll
Of
file.
course, we'll take and give a copy to him.
My lord. I'll taken up tomorrow. I'll give.
Right.
Babita Kumari Patnaik.
Babita Kumari Patnaik, Land Council for the petitioner, submitted that the petitioner has approached this court challenging the order passed by the London Central Administrative Tribunal Cuttack Bench dated 2/4/2024 in OA number 589 of 2017, in which the London Tribunal disposed of the original application with a direction to the respondents to consider his case in terms of the scheme dated 22/8/2019 and to communicate the decision to the applicant within a period of 90 days from the date of receipt of this order. The petitioner was working as the technical helper, no?
My lord.
Technical helper in where are you working? Technical helper in Doordarshan.
In Doordarshan, Paradip.
In Doordarshan. According to the Land Council for the petitioner, similarly situated persons also approached the London Central Administrative Tribunal Cuttack Bench Cuttack in PA number 34 of 2009 and other connected applications, and all those matters were heard analogously and disposed of by a common order dated 12th March 2018, and the respondents were directed to take necessary steps and pass orders for regularization of the applicants from the date of their initial appointment with consequential benefits by following necessary rules with regard to conferment of temporary status and consequent regularization. It is the contention of the Land Council for the petitioner that the said order passed by the London Central Administrative Tribunal was challenged by the respondent before this court, which was dismissed, and the respondents also approached the Honorable Supreme Court, but they remained unsuccessful. And thereafter, all the persons who are similarly situated, the services of all the persons who are similarly situated have been regularized. The copies of the judgment passed by this court, so also by the Honorable Supreme Court, has not been filed. The Land Council for the petitioner submits that he will file those copies during course of the day with a memo giving copy thereof to the Land Council, Intergovernment Council. If the name, etc. Yes, is this matter tomorrow? Yes.
Okay.
Item 3.
Item 3 the permitted to order, my lord.
Filing a memo.
Yes, yes.
The land council for the creation of files and disposal of.
Problem.
Item 4.
Nay, please, your lordship. Here I have challenged the annexure 4, my lord, order passed by the ADM Raulkela on 18/4/2024. My lord, in this case, what has happened with the petitioner was allotted with a plot in the industrial area of Raulkela. Later on, it was cancelled. Against that, the petitioner filed a WPC number 4604 of 2009, which has been disposed of on 17/2/2022, with the liberty to file an appeal under Rule 9 of the OGLS Act before the government. Under Annexure, we have filed the appeal matter. Under Annexure 5, that was returned to file before the ADM. At page 43, my lord.
43 or 45? 43, Annexure 5.
Annexure 5.
4.
Is the order passed by the government?
Government, my lord. To
Right.
return it and directed to file us before the ADM Raulkela, who will in turn send all the Parawai's comment or other documents to the government for hearing and disposal. But unfortunately, the ADM has disposed of the appeal.
But did not send the records
No,
to.
no, man.
So we come to the operative part of that page 45.
Yes.
Well,
Just read that. You filed an application under Rule 9 of the OGLS Amendment Rules,
Meller,
1987.
Meller.
And what order has been passed? Just
That is Annexure 4 at page 41.
no. Just
No.
read that Annexure 5.
Yes, Meller. In writing reference to your appeal petition dated nil on the subject cited, I am directed to say that the appeal under clause 9 of the schedule such and such OGLS Rule 1983 lies with the government in the revenue department. However, appellant has to file the appeal petition with required court fee before the ADM Raulkela, who in turns with all relevant document and views in the matter shall forward to the revenue and disaster management department for hearing and decision. Hence, your original petition is written here with advice to
Now,
file
what-
some
Thereafter, you preferred an appeal.
appeal. Under Annexure 1, I have filed.
Okay. And that was
Disposed of.
disposed of.
Disposed of. Under Annexure 4 by the ADM.
What he has held in that Annexure 4?
Page 42 is the operative portion,
Yeah.
Miller.
Annexure 3 na response.
Annexure 4 is 43.
Annexure 3 is the order of the
Oh,
ADM.
sorry,
Page
Annexure
44 you say.
43.
Page 4 is the government order.
No, you see page 44, the operative part of the ADM's order.
There is no page 44 so far my brief is concerned.
Not there.
Ago page ta, ago page ta.
अच्छी अच्छी
Page 43 जाए last page.
Eight ta, ago page ta.
ତା ପୂର୍ବ ପେଜ ଟା
Ta
ଦେଖନ୍ତୁ
purvo page ta.
That is 42.
ହଁ ସେଇଟା ପେଜିନେସନ ଟା ଠିକ
Since your firm is already enjoying possession of a land earlier, its claim for further alignment of the land appears not to be genuine and therefore it deserves no further consideration. Therefore, the LSC once again rejected the case in the right way. The matter has been dealt with in the light of natural justice and established legal conclusion.
So,
So-
let us see that provision, that OGLS Rule 83. OGLS Amendment Rules 1987. Na? Your application was filed under which provision?
Rule 9.
Rule 9 of OGLS Amendment Rules 1987. बात करिए थी। 1987 amendment.
ଏଟା ହେଲା ଏଟା 23 ର section 9 permissive provision temporary settlement. Which one is the provision? Yes, Odisha government land settlement rules.
Odisha government rules settlement. এটা কোন এটা? Odisha
Government land settlement rules.
land settlement amendment
Amendment
rules
rules
1987.
87.
यहाँ पे 83 ଅଛି
ସେ ତାଙ୍କୁ କହିଦେଲେ।
24 it is ଥିବା କଥା 2024
83.
83 na
83.
ah
But
83 that
but
is
wrongly type 87. It is
that we
83.
are having.
Rule 9.
Put it. Government land settlement. ଅଲଗା ଅଛି ଏଠି temporary settlement ଅଛି permissive position ଅଛି 9 ରେ review କଥା ନାହିଁ.
This is 83, it's not 87.
No, 83, my lord.
You bring that book, Amendment Rules 1987.
My lord. But let it come to next week, my lord. I'll bring.
The writ petition has been filed by the petitioner, Pitavas Mishra, for a direction to the ADM Raurkela Secretary, opposite party number 2,
My lord.
to submit the appeal memo along with all relevant documents to the Secretary Revenue and Disaster Management, Government of Odisha, for disposal of the appeal. Land Council submits that when the petitioner preferred an application under Rule 9 of OGLS Amendment Rules 1987, before the Secretary Revenue from a Government of Odisha at Bhubaneswar, he received intimation from the government by letter dated 2nd April 2022 that he has to file an appeal petition with required court fees before the ADM Raurkela, who in turn, with all relevant documents and his views in the matter, shall forward to Revenue and PM Department for hearing and decision. And accordingly, the original appeal petition was returned. It is further submitted that in pursuance of such letter, the petitioner referred the appeal before the additional district magistrate Raurkela and by Annexure 4, the opposite party number 2 held that the farm of the petitioner was already enjoying possession of a land earlier, and its claim for further allotment of land appears to be not genuine and therefore deserves no consideration. And accordingly, the application was rejected. It is the contention of the Land Council for the petitioner that when by Annexure 5, the government has asked the petitioner to refer the appeal petition before the opposite party number 2, who has to forward it to the Revenue and DM Department for hearing and decision with all relevant documents and his views. It was not proper on the part of the opposite party number 2 to reject such a without forwarding it to the concerned authority. After hearing for some time, the land counsel for the petitioner seeks for an adjournment till next week. Put up this matter in week commencing from 25th November 2020. Yes.
Item 5.
Right.
Please, my lords. This is a second round litigation, my lord.
देखिए ना
My lord, arising out of a resumption proceeding, and the resumption proceeding having been disposed of without affording reasonable opportunity to petitioners, my lord, they approached this honorable court in WPC number 15867 of 2008, my lord. And the honorable court, in due consideration of the grievances of the petitioner, set aside the order passed in the resumption proceeding and directed the Tahsildar to hear it afresh. Similar application challenging the vendor's title was filed before this honorable court in another writ petition, my lord. And pursuant to the direction, they appeared before the Tahsildar, and when the matter was in course of hearing, they received a notice by answer 2 from the collector, my lord. That was in compliance to a direction given in the second writ petition, my lord, regarding the title of their vendors. Now it was a pursuant to the said notice, my lord, they appeared before the collector in miscase number 7 of 2010. There the title was decided, and Tahsildar was directed to proceed in compliance to the order of the honorable court. And that matter was disposed of since 23/11/2012. And the petitioners are running from pillar to post. No action has been taken, and the RTA application was also remained unanswered. And answer 4, my lord.
So what do you want now?
Lord, I beg to say that this order by answer 3, my lord, may be complied with, my
What is annexure
by the Tahsildar.
What is annexure 3?
Annexure 3 is the order of the collector, my lord.
What direction was issued or what order was passed? Come to the operative part. Let us see what order was passed.
Lord, you may kindly turn to page 19. There, my lord, this honorable court's order that the petitioners are directed to appear before the Tahsildar in the week commencing 12 January 2009, and on their appearance, a date shall be fixed for hearing of the case. The petitioner shall be permitted to produce all documents. It was produced. They appeared and produced. And subsequently, they received a notice.
So
It was another case.
But
Now, my lord, the vendor's title has been decided.
So in miscase number 7 of 2010,
my lord,
which was disposed of on 23/11/2012 by annexure 3.
My lord.
So what order was passed? Please come to that portion.
Vendor's title was decided. Now the fact remains.
It is 25. Come to that operative page number 24.
24, my lord. However, my lord, a second paragraph. However, Solimuddin Khan, being a Jawan, has been benefited after declared eligible for such concession by the government authority.
Page 4, internal page, running page 24.
24.
Hala? So,
in view ହେଲେ ପଢନ୍ତୁ, in view of the papers available, ସେଇଠୁ ହେଲେ ପଢନ୍ତୁ।
ଗୋଟେ ଆରମ୍ଭରୁ ପଢନ୍ତୁ, ମାନେ
ଆରମ୍ଭରୁ ପଢନ୍ତୁ।
ମଝିରୁ କୋଉଠୁ
Yes.
ହଠାତ୍ ପଢୁଛନ୍ତି ଜଣା ପଡୁନି।
That is the operative question I placed.
In
view of the papers available in lease case number 472 of 6869 and the order sheets thereof, it appears that maintenance of the case record is very poor and maintained in a confusing manner. The Tahsildar should have to maintain two separate lease case records for both the Jawans to consider the sanction of government land in their favor. Due to non-application of judicial mind in passing orders, irregular processing of the case record and inclusion of the eligibility of Solimuddin Khan declared in the letter number 2378 dated 18/4/72 to the case record leads to believe that the assignment of government land to Shafiquddin Khan has been overlooked, although this case was to be considered in the first instance. However, Solimuddin Khan, being a Jawan, has been benefited after declared eligible for such concession by the competent authority. In the meantime, the land settled in favor of Solimuddin Khan has been resumed and taken to government khata. The said resumption was challenged in the Honorable High Court, Odisha in WPC number 15867, and the Honorable Court in its order dated 2/12/2008 set aside the resumption order and directed the Tahsildar Bhubaneswar to dispose of the resumption proceeding afresh. And we are the beneficiary of the said order. Now, my lord, the Honorable Court has harped on the order of Tahsildar dated 5/10/2004, which might be inadvertently mentioned instead of 5/10/2002. In the said order, Honorable Court expressed their concern over the reason behind deletion of Shafiquddin Khan and inclusion of Solimuddin Khan, as no satisfactory explanation was tendered to the court. On scrupulous study of the said order of additional Tahsildar, it appears that keeping in view the settlement made in favor of Solimuddin Khan, the additional Tahsildar herself has made correction on the order sheet by following her initials in all the places of cutting starting from the order sheet to her spot visit memorandum. The said mistake has been arising due to use of pre-printed order sheet filled up by a clerical hand susceptible to error. If the additional Tahsildar herself has written the final order, then there would not have been any such error in the case record. Therefore, I am of the view that such error is very much incidental but not intentional. Before parting with the case, it is observed that the matter assignment of land in favor of Shafiquddin Khan has not yet been disposed of, and in the changed scenario, government in Revenue and Disaster Management Department are competent to consider the same. As such, Tahsildar Bhubaneswar is instructed to do the needful in this issue at his end forthwith. Now, my lord, so far the settlement of land.
What happened then? Tahsildar Bhubaneswar.
He is not doing anything. That is my grievance, my lord.
No, you are approaching this court after so many years.
No, my lord, I am going. Your lordship may kindly
this
see that
order under Annexure 3 was passed in 2012, and there was some direction to the Tahsildar. So, if the Tahsildar was not taking any action, what you are doing for last 12 years?
We are going there. We are approaching the authority, and irrespective of the fact that RTI application was made by
application was made in only in June 2024. After 12 years.
Thereafter, my lord, they are going. They are going to the office.
What kind of steps you have taken in between?
We are, my lord, we are not in error. We are not in error, my lord.
Then why to again agitate? You wait for another 12 years. You could wait for 12 years.
Go on approaching, filing representation, whatever you like.
That in relation to the Shafiquddin Khan, the petitioner's lordship may kindly glance. They have not enclosed a document how the right accrued in favor of the petitioner to claim over the.
Who are these petitioners? By
yes, petitioners are the purchasers, man.
Where there is no proof at all.
Where is the document?
That was decided, my lord. That was decided in the
petition. Was decided.
My lord, Annexure 1 is. Why Annexure 1, my lord?
Annexure 1 that was not filed by you. What?
That was filed.
One decided.
Yes. Was filed the original list. They are stepping in the shoes of original lessee. But where it has been decided in their favor, that is not there to decide for
My lord,
decision.
my petitioners are same as in the writ petition, my lord. They are all
The
purchased.
lease has an original lease has not been produced. Whatever the lease transferred in his favor or by way of
Not
sale, that is
necessarily,
not
my lord.
there.
In view of the resumption order, my lord, this Westland lease case number
No, but
472.
unless the land is resumed in favor of the original lessee, you will go by the fate of the lessee. You have no role to play. You will go by the fate of the original lessee. If the land is not resumed in favor of the original lessee,
Their
where are you?
transfer is, my lord.
Where are you?
After, my lord, the land was transferred after the lockup period, my lord.
No, no,
Now-
that is not the question here. Question here is the matter has to be decided afresh with regard to the resumption.
Resumption.
So unless the
No, my
resumption
lord,
is
two writ petitions are there. In one of the writ petition, my lord, in my writ petition, my lord, the petitioners, the resumption proceeding was set aside.
no, but it is to be taken afresh. That is the direction, and that is also the direction given by the
Yes.
order dated in miscase number 7 of 10.
No, my lord, perhaps I am.
No, you read it.
In the original order also direction is they produce all documents for consideration.
And that was produced before that court. My lord, while the matter was on the process of adjudication, he received a notice from the collector because another petition was filed challenging the ownership of the vendors.
What are those documents to show that something was under consideration of the Tahsildar Bhubaneswar? What is the number, case number, or anything like that?
That is, my lord,
You said
annexed
that you received a notice from the collector.
My
At
lord.
that time, something was in progress before the Tahsildar Bhubaneswar. So, what was that proceeding that was in progress before the Tahsildar?
That is that miscase number 7 of 2010, my lord. I was directed to appear in that case, my lord. So, lordship may kindly have a glance to the order.
It is
by the annexed
it is for this reason that this court, while passing the order, had made it very clear that there are factual disputes. There are the factual disputes which have given rise to the present petition. So many factual aspects are also involved. Whose title is there, lease has been granted or not, who is the lessee, because there are two identical persons, two separate record has not been
That is
maintained.
decided in the proceeding before the collector, my lord. It is miscase number 7 of 2010. It is decided.
No. Court decided.
It is decided, my lord. I have placed that portion of the order.
Here
my lord.
to take step on scrupulous study of the said order, the additional Tahsildar, it appears that keeping in view the settlement made in favor of Salimuddin Khan, the additional Tahsildar herself has made correction on the order sheet by following her initial in all places of cutting, starting from the order sheets to her spot visit memorandum. The said mistakes have been arisen due to use of pre-printed order sheet filled up by a clerical hand, susceptible to error. Before parting with the case, it is observed that matter of assignment of land in favor of Safiuddin Khan
has not
not
been
yet
disposed
of.
Disposed of. It is
And in
pending.
the change scenario, government in revenue department, disasters management are competent to consider the same. As such, Tahsildar Bhubaneswar is instructed to do the needful in this issue.
My lord, that is why once the finding was that the application of Safiuddin Khan is pending, it is not disposed of. Then disposal is Salimuddin Khan's case was disposed of.
When you file your that RTA application under Annexure 4, because you yourself was not aware what has happened to that proceeding.
No, because I remained in dark regarding all the proceedings.
You remained in dark when you filed this application. Then what happened to that application?
They are not supplying any information. They received it, but
there is a provision for appeal. If somebody is not RTA Act of provision achi, jadi apana.
They have preferred appeal perhaps, but
no question of perhaps.
I will ascertain and say whether
against if an authority before whom the application is filed is not responding, then there are provision in that RTA Act itself.
My lord, may kindly have a glance to the matter was already discussed, my lord. Two writ petitions were filed before this court.
That we will pass the order to the
Tahsildar
to supply you those documents.
No.
Then
I beg to say that the order of the collector may be complied with. That is answer 3.
we do not know. It might have been disposed of already.
No, my lord, it is still pending because they are not.
You yourself is not aware. That is why you sought for
Let the state be directed to.
So why state will say you have a provision if some authority is not responding on your application and you have alternative remedy available by filing an appeal against the conduct of this authority in non-supplying the document, and you are not availing the same, you are coming to the High Court. Why we'll pass the orders when the quorum is available?
The apparent illegality, my lord, when there is a finding that my vendors have a title.
You take that appropriate recourse. It appears that the petitioner has has filed an application under RTI Act before the Tahsildar, Bhubaneswar Tahsil, for information, for supply of information regarding page number
status of miscase from 7 of 10.
page 26,
Right.
Which was submitted on 16/6/2024. When a query is made that to the London Council for the petitioner as to whether any information has been received from the Tahsildar, the answer was in negative. When since there is an appeal provision against the inaction of the authority and the petitioner has not availed the same, the petitioner is at liberty to avail such a remedy in accordance with law. Accordingly, the writ petition is disposed of. You get those documents and then you prepare the.
Well, but I beg to say that they.
Item 6.
Item 6, Lordship are directed to take instruction, my lords, as per the order dated.
To balance compensation.
Yes, my lords. Lords, it has not come, my lords. We have sent the letters, my lord. Lordship may 10 days time may kindly.
All right. The Prabhu Prashanna Beharal and an additional standing counsel submits that as for the order dated 30/10/2024 is yet to receive the instruction and the matter may be taken up a week after. List this matter in the week commencing from 9th December 2020. Yes.
Item 7.
Wait, please, Your Lordship. My Lord, item 7, I am in BC, my Lord.
Yeah.
My Lord, in this case, Your Lordship, the petitioners have approached this Honorable Court being left without any remedy by the government authorities. Your Lordship may kindly see, this is regarding the initiation of land acquisition proceeding and paying of compensation. My private land has been acquired by government for the construction of guard wall on River Tail on the left portion of River Tail in order to check inundation and flood. But Your Lordship, no proceeding has been initiated and the petitioners have not paid any compensation. Your Lordship may kindly see, we are undisputed owners of scheduled land. Scheduled land I have already described at page 7. Just above the prayer portion I have mentioned.
Or the legal notice on the state of Odisha on
Yes, Your Lordship.
2024.
They have received it. They have, even Your Lordship may see the tracking report I have annexed page 20. They have received it. They have received, my Lord. Not doing anything. It's a very, the state action, Your Lordship may kindly see the state.
You have not received any response from on your advocate's notice.
No, my Lord.
All right. We are directing that should be treated as representation and communication is to be made.
Let them, Your Lordship, take proper action on my notice.
The petitioners have filed this writ petition with a prayer for a direction to the opposite party to pay just and equitable compensation for acquisition of the civil land of the petitioner with such a rate of interest as deemed fit and proper, and to release all other benefits under the rehabilitation and reassistance scheme as was released in favor of all other landowners. The Land Council for the petitioner submitted that highlighting uh, the grievances of the petitioner, a legal notice was sent on 6/1/2024 by Annexure 3 series to the
Collector.
that is opposite party number 2 on 6/1/2024. And the same was received by the concerned authority, but the petitioners, neither the petitioners nor the advocate received any communication from the opposite party number 2, and no compensation has yet been paid. And therefore, direction be issued to the concerned authority to treat the Annexure 3 series as a representation of the petitioner and to dispose of the same in stipulated period, and the result thereof be communicated to the petitioners. Considering the Land Council for the state has no objection, considering the limited nature of grievance, this court direct that if the Annexure 3 series is still sub judice pending before the opposite party number 2, the same shall be treated as a representation of the petitioner, and that's be disposed of within 3 months from the date of production of the certified copy of the order along with a copy of the writ petition, and the result thereof shall be the decision taken on such representation shall be communicated to the petitioners within 2 weeks from the taking of the decision. It is made clear that we have not expressed any opinion on the merits of the claim of the petitioner. Yes, disposed of.
My lord, may I make a small prayer, my lord? Your lordship may be kind enough to direct that the order be communicated to appointment number 2 at the cost of the petitioners.
All right,
They will come. They will come.
come.
My lord, I will go and produce the certified copy. Your lordship may direct at my cost, let it be communicated to the petitioner. I will deposit the cost today.
No, that will be better if you produce. That is the order you usually pass. So you produce it before the collector and with the copy of the writ petition. That's all. Yes, next.
Obliged.
Item 8.
One is there. Also,
Please,
8.
you are there. Okay.
So, an interim application for amendment was there.
What amendment you want, Mr. Das?
to implement the superintending engineer, deputy dominators.
As opposite part number 5.
Yes,
Where is that IA? Competent. Item number 8.
26843.
Have you received a copy, Mr.?
No, my lords, we don't have the copy.
I will not given a copy.
date.
Just to
Date.
happens.
Aji debe.
No, date. File collapse.
Yes, it's not given.
Consul-
Receipt is available with you.
Consolidated.
Okay. No, you should give it. That's all right. But give it. IS also.
I have already given.
He says that no, that is why we
Well,
are.
it's not there in the file. I'll check if my learned senior gives an extra copy.
All right. This interim application has been filed by the petitioner seeking for amendment and to incorporate superintending engineer TPWODL electrical, circle, Balangir in the cause title as opposite party number 5. The Learned Counsel for the state has no objection. Accordingly, the prayer made in the interim application is allowed. So and so is permitted to be impleaded as opposite party number 5. The Learned Counsel for the petitioner files the consolidated writ petition in court today, which is accepted. A copy of the consolidated writ petition is also served on the Learned Counsel for the state.
State as well as copy number 2 to 4.
So, what do you want now, Mr. Kar?
Yes, in this case, Lordship, in this case, Lordship direction was given to serve a copy on
You
Mr.
are
Anindya
for-
Kumar Mishra.
You are for?
I am for opposite part number 3, 4, and the newly implemented opposite
Just-
part number 5.
just a minute.
Has instruction to appear on behalf of Mr.
Opposite
Prashant
party.
Kumar Tripathi. He has instruction to appear for the
So,
TPW.
no, not only that, but today also, since this superintending engineer
He's
has
appeared.
also been, so you will appear for
Appear.
3, 4, 5.
3, 4,
So
5.
please serve a copy on.
Yes, I will.
Please give the name who are supposed
My
to
lord,
appear
my lord.
for the litigants.
Online.
X-ray.
Otherwise, even.
Acha, you filed also the soft copy of that consolidated writ petition. All right, the soft copy of this one. Let a copy of the consolidated writ petition be served on Mr. So and so, who submitted that he has instruction to appear for opposite parties of those opposite parties for those opposite parties. You will file your vnama
My lord, by next week. By next week, my lord.
By next week. Matter be listed in the week commencing from 9th of December 2024. The instruction be obtained by both the opposite parties number 1 and 2, so also the opposite parties number 3 to 5 in the meantime. Yes.
Item 9.
Please, my lord. The order of Central Administrative Tribunal is under challenge by the Annexure 13, my lord. The petitioner was appointed as multitasking staff, my lord, and the termination has been made due to suppression of facts in the letter of affidavits, my lord.
What is the prayer made before the?
And prayer before the.
Come to the page number 100, running page and internal page 2. Your prayer portion has been quoted there.
My lord.
That is the condition of. What is your prayer?
The prayer for passing of the appointment termination letter, my lord.
Where is that original application? Have you filed a copy of that?
No, I have not filed a copy of original application.
So how can we know that what was your prayer? Where it is been quoted in that order of the Learned Tribunal?
My lord.
Only 6, my lord.
106.
Yes, my lord.
The prayer portion.
Yes, yes.
Okay.
That has been quoted by the Lord.
Thereafter, the applicant approves this tribunal in the present IO. Okay. So, page
106.
106. So, your prayer is read out those prayer portions.
Lord prayer, and further be pleased to set aside the order of termination dated 16/8/2018 under Annexure A by 7. And further be pleased to direct the respondents, the applicant be permitted to continue the work till disposal of the criminal appeal on provisional basis. And further be pleased to set aside the order dated 2/1/2023 passed by the Superintendent RMS and Division Cuttack.
So what happened? Some proceeding criminal case was instituted against you or what?
Yes, my lord. Criminal case was instituted.
What type of case it was?
My lord, the petitioner was charged on 423, 424, and 425, 320. And
what happened in the trial court?
Trial court.
No, including 302149.
No, I have not conducted.
What are the charges?
Yes.
My lord asked you. The charges are 147, 168, 341, 294, 324, 325, 336, 427, 307, 302, 149.
Yes, so everybody has been charged.
Yes,
There is no segregation of charge as it appears from the
Judgment.
page number 2 of the judgment,
My lord.
which you have annexed the judgment passed by the learned additional session judge Sonpur.
My lord.
It appears that as many as 29 accused persons were facing trial.
Yes, my lord.
And one of such charge, as my esteemed brother pointed out,
Yes, my lord.
is under section 302.
My lord.
So what happened ultimately? The learned trial court, what has been held?
My lord, kindly come to the.
You are the accused number.
I am 5, my lord.
Accused number 5.
My lord.
Right. So come to the concluding paragraph. Who
My
has
lord,
been
69, page 69, my lord. Paragraph 23, my lord.
just a minute. 69. Yes. Yes.
My lord, from the judgment's concluding part, my lord, I am reading, my lord.
Accordingly, I hold. Just read out that.
Yes, accordingly, I hold accused Dipa Tandi, Daitya Tandi, Kanchu, Chandramani, Sadnan Buddha,
Sudam, Buchu,
Yes.
Jasoda, Barijugi, Pahala, Okin, Bhalu, Tapasini, Supasini, Sobati, Gopo, and Raibari.
So they were found
Acquitted.
not guilty, actually.
Not guilty of all the
Okay.
charges and acquit from the offenses
All right,
under
sir.
so and so many.
Further hold that
And
all the
further
accused
hold that
persons
all the accused persons are not guilty of under section 341, 294, 307, 336, 427 IPC and acquit them from the said charges. All the accused persons except Bibha and Khemi are held not guilty of 302, 149 IPC and acquitted them from the said charges. I further hold guilt accused Bibha and Khema guilt under section 302, 34 IPC and convict them thereunder. Similarly, I hold accused Bhagavati,
Bibha,
Utta, Khema, Binod. Binod is the present petition.
So
Kirtan, Prabha, so and so, guilt under section 323, 149, 324 and 325 and convict them thereunder.
So you have been found guilty under 323 by 149, 324 by 149, 325 by 149.
My lord.
And sentence has been imposed, and this judgment was pronounced on 13th February 2004.
My lord.
So against this judgment,
appeal has been
you
filed.
have preferred an appeal.
My lord.
So what happened in that appeal?
My lord, appeal have filed also judgment, my lord, annexure 8.
Annexure 8. The appeal has been disposed of or still pending?
No, disposed of, my lord. It is ending in the SLP, my lord.
No. This court.
No. CRLA.
What happened to that CRLA?
My lord, CRLA has been
in that judgment is there. This.
Yes,
I
I
mean to say that annexure 8 is the judgment.
Yes.
So what happened in that ultimately? It is
confirmed, my lord.
Confirmed.
Yes,
ma'am.
Just show that line.
My lord, page is 88, 89, my lord.
88.
For all the aforesaid reasons, the court finds
bail
that
bonds of
well
the
reasoned
appellants
order of the trial court
they
calls
are
for
directed to
no
surrender forthwith. If they do not do so on before 1st June 2022, the IC concerned police station will take immediate steps to have them arrested and taken into custody to serve out the remainder of their sentence. The appeal is accordingly dismissed.
So your appeal was dismissed, right?
My lord.
Appeal dismissed. Then what did you do?
Then my lord, SLP filed, my lord.
What happened?
And SLP, my lord, period undergone has been, my lord. Annexure 9.
9.
Annexure 9, my lord, page 90.
Considering the totality of circumstances on record, including the physical disability of the appellant, in our view, the appellant is entitled to be granted benefit of reduction in sentence in respect of offence punishable under 325(149). Sentence already undergone. Oh, that means confirmed, but
Confirmed sentence. So what happened then?
My lord, in para 7, my lord, kindly have a glance to the judgment of the SLP at page 91, my lord. According to the record, the appellant was started to be armed with a lathi, which was used by him in the transaction. The petitioner was 90% disabled, my lord.
No, what do you want to? We want to appreciate the evidence now or what?
No,
your sentence has been confirmed. Your conviction has been upheld and the sentence has been reduced.
Yes.
So what do you want now?
My lord, my humble submission before your lordship, my lord. The section is the grave the petitioner only on the ground of suppression of facts he has been terminated, and he is 90% disabled person, my lord.
Where is the termination order?
My lord, termination order, my lord, is
38, Annexure 6.
Annexure 6, my lord. 38 to 40.
Okay.
And they have also not.
Just a minute. Binod this and so and so. This is the termination order. It is propounded that the suppression of the facts committed by so and so. So what you suppressed that you have been found.
My lord, regarding pendency of the conviction, I have not my criminal case. I have not mentioned in this.
Asha, then what happened? You were terminated. Then
yes, I have terminated and I made a representation. They have not considered, and I filed before the tribunals, and during the pendency of the tribunals, SLP disposed of, and after disposal of SLP, I filed another representation application to the authority to consider my case in humanitarian ground, as I have unemployed and 90% disabled persons, and the conviction is minor in 325, my lord.
No, your article of charge is only suppression of fact regarding the
case. Tendency of the case.
No, kindly come to Annexure 6, middle paragraph. In obedience to this office, memo number such and such Sri BC was attended this office with requisite documents along with 2 sets of attestation forms duly filled in for necessary verification at this end. And BC was provisionally appointed. You have forged your signature.
My lord?
You have forged your signature. That is, article charge is different. Subject to condition. The appointment is provisional, subject to satisfactory completion of prescribed training and the certificate being verified through paper channel. If the verification reveals that the claim of the candidate belonging to scheduled caste, scheduled tribe, or other backward class is false, or educational certificate are not genuine and found unfit on police verification, his or services shall be terminated. Eithre kon hala?
Only on the ground of suppression that I have not mentioned about the pendency of the criminal.
Just come to page number 39 and see the conclusion part.
Yes.
Just read out that from I have
carefully gone through the reply to the so cause of Mr. Binod BC dated 37/2018, and the same is not convincing at all. Sri BC has mentioned no and NA against all the sub-paras of para number 15 in the attestation form, for which it is proved that he know everything while submitting the attestation form. Again, Sri BC also undertake it that the attestation form that I am fully aware that by providing false information or suppression materials information while filing this form, the authority have a full right to terminate my appointment letter, and I am also liable for appropriate criminal civil actions as a consequence. CBC is fully aware of the fact as mentioned in the warning section of the attestation form as under. Furnishing of false information or suppression of any factual information in the attestation form should be disqualification and is likely to render the candidates unfit for employment under the government. If detained, arrest, prosecuted, bound down, fined, convicted, debarred, acquitted, subsequent to the completion and submission of this form, the details should be communicated immediately to the authority to whom the attestation form has been sent, early as the case may be, failing which it will be deemed to be suppression of actual information. If the facts that false information has been furnished or that there has been suppression of any factual information in the attestation form comes to notice at any time during the service of a person, his service should be liable to be terminated. Order. In view of the above, it is propounded that the suppression of facts committed by Sri Vinod BC, MTS HRO, so and so, Cuttack, knowingly deserves appropriate criminal civil action. I, Sri Aditya Kumar Naik, Senior Superintendent RMSN, Cuttack, after careful going through the evidence, available records of the case of Vinod BC, ordered that provisional appointment be terminated with immediate effect.
So is that order you challenged before the learning tribunal?
My lord.
So what the tribunal held?
Tribunal held that a suppression facts in the services justified has been made, so the termination is justified. My lord.
So how do you challenge that order? If that is the order, are you disputing that all these the a 3-0 case was instituted against you? You have been found guilty, of course, of lesser offense and sentenced, and you preferred an appeal. The appeal was dismissed, and then you preferred SLP. That was also confirmed, but the sentence was reduced. So all these things, whether it was on your part, it was required to be informed to the employer or not.
I have informed afterwards, my lord. After after getting the so-called notice, when I give my reply, I have mentioned.
No, when it was required to be informed.
It is that
thereafter question is that when it requires a point of time when you are supposed to inform me. So as per the rules, what was that point of time?
My lord, at the attestation form, my lord, I should reflect all the truth, my lord, regarding pending. There was a column also.
Yes.
Regarding the
because you make a declaration before the authority that no criminal case is pending against me.
Admittedly, that has been done, my lord. That
is your entry
mistake
point
has
in
been
this
done, my lord, by the petitioner. But in the reply, petitioner has admitted that as he is a poor fellow and due to loss.
You see, if you in that particular application form, you would have mentioned that I have been prosecuted for an offense under section 302 IPC.
Yes.
The authority might not have given you appointment.
Yes, in that fear he has not mentioned, my lord.
So, that is suppression.
This is
amounts to suppression of that.
This he has admitted in his so-called manner.
Yes.
And you are mentioning something wrong, and that ultimately has been taken into account. The authority was
provisionally appointed
under impression that there is no criminal case.
Yes,
so that is how they give you appointment. And subsequently, it was found that you whatever you have mentioned, it is not a correct one.
Yes, my lord. All these proceedings started, my lord, due to suppression of facts.
Right.
And the suppression of facts, as I have in my reply, has mentioned that as I am a poor fellow and loss of job due to fear of loss of job, I have not mentioned in the that has been admitted. He has
by that time you have not entered into the job. After this criminal case was instituted,
yes,
you got the appointment. It's not that this case was instituted in the case number is 2000, right? So the occurrence took place in 29/3/2009.
Yes.
That is the date of occurrence, right? So when you got the appointment?
In 2016, my lord.
2016, 7 years thereafter. By that time, you have already been convicted, right? So even if you have been convicted, facing a trial under section 302, you are submitting a report before your authority that there is no criminal case pending against you. So if let us say 5 persons applied for that particular post, and on the basis of your representation or on the basis of your application, when the authority find that you are otherwise qualified and in addition to that, you have not having any criminal case against you. They gave you appointment. Now, think of it a situation that you were mentioned that I have been found guilty. I have faced a trial under 302. I have been found guilty. Whether the authority would have given you appointment,
No, my lord.
then so that is the requirement at the initial
Yes.
stage. You have not come up with a clean hand. You are suppressing something. That is how the proceeding was instituted.
Yes, my lord.
And you are also not disputing that, yes, I have submitted a wrong, given a wrong statement before my authority. Perhaps you are under impression that if I give that correct information, I would not get that service. That is your case.
Yes, my lord.
So now, in these circumstances, how do you meet this the order of the Learned Tribunal?
My lord, I have taken ground that in the that disproportionate of punishment, my lord. The termination, my lord, is 90% disabled persons, my lord. And
Madam, you are not entitled to be taken in employment, and now you are saying that disproportionate.
And my lord, as they reflect that appointment letter, my lord, 65 rules has also been not followed, my lord. And on the
You come
ground
to the
that
operative portion of that judgment of the passed by the Learned Tribunal. Paragraph number 15,
my
that
lord,
is at page number 122.
my lord. Further, it is seen that the applicant has himself admitted that he did not disclose in the attestation form about his involvement in the criminal case out of fear of his automatic disqualification. We do remember a well-known proverb that one man's food is other man's poison, meaning thereby that had the applicant not suppressed, he would not have been selected, and in his place another person could taken the berth, which is clearly applicable to the present case. Further, it is well settled law that whoever comes with clean hand is entitled to equity. Here, in this case, the very approach and intention of the applicant is proved to be ulterior, and hence the termination of his service being done based on rules after giving him so cause notice and as per the conditions stipulated in his offer of appointment. No lenient view in this facts and circumstances called for.
So, how do you challenge this order? What are your grounds you have taken in your writ petition challenging the order?
My lord, I have taken the ground that the
Let us see your grounds.
paragraph 18, from paragraph 18, I have my grounds.
Yes.
I have taken the ground that first of all, this incident has taken place at the very early stage of the petitioner at 19 years, and for which his case should be taken in consideration in a lenient view manner. And the major punishment like termination should not be inflicted upon him. And as the appointment letter, my lord, in the appointment letter, it has been mentioned that 65 rules is 65 temporary service rules is applicable to the temporary appointees. That has not been followed. On the
What it says?
in the appointment letter, my lord, appointment letter at annexure 2, in the relevant page, my lord, at 29, my lord, it has been the appointment is also subject to following terms and condition.
Where are you placing? Page 25.
Page 29, my lord.
29.
And the
Just a minute. Yes.
And the one says that
CCS Temporary Service Rules 1965 as
Yes.
amended from time to
time
time.
and
So
will
how
not
do you say that this has not been followed while terminating you from the service? Where is the termination, or that you have been asked, you have been given a show cause,
Yes,
you
ma'am.
have given your reply,
Yes, ma'am.
and then the order has been passed,
Let
right?
us-
Annexure 6.
Yes, ma'am.
So, of course, it appears that after going through your show cause, the no further thing has been done. So what that rule says?
My lord, that rules I have quoted in paragraph 17, my lord.
Let us say paragraph 17.
No, paragraph not 17, my lord, just in judgment also that has been quoted. I have
Not in
in page 13, my lord, I have quoted rule 5.
Page 13.
Page 13 of my brief, my lord.
Page 13.
And under the ground 8,
Okay.
my lord.
Rule 5 you have quoted.
My lord.
Yes, please.
The service of a temporary government servant shall be liable to termination at any time by notice in writing given either by government servant to the appointing authority or by the appointing authority to the government servant. The period of such notice shall be 1 month, provided that the service of any such government servant may be terminated forthwith, and on such termination, the government servant shall be entitled to claim a sum equivalent to the amount of his pay plus allowances for the
Yes.
period of notice at the same rates at which he was drawing them immediately before the termination of his service, or as the case may be, for the period by which such notice falls short of 1 month. Note, the following procedure shall be adopted by the appointing authority while serving notice on such government servant under clause A. The notice shall be delivered or tendered to the government servant in person where personal service is not practicable. The notice shall be served on such government servant by register post, acknowledgement due at the addressee of the government servant available with the appointing authority. If the notice sent by registered post is returned unserved, it shall be published in official gazette, and upon such publication it shall be deemed to have been personally served on such government servant on the date it was published in the official gazette. 2. Where a notice is given by the appointing authority terminating the service of a temporary government servant, or where the service of any such government servant is the period of termination and the expiry of such notice, or forthwith the central government or any other authority specified by the central government in this behalf, or a head of department, if the said authority is subordinate to him, may of its own motion or otherwise reopen the case, and after making such inquiry as it deems fit, confirm the action by the appointing authority, withdraw the notice, reinstate the government servant in service, or
We
make
have gone through it.
yes, ma'am.
Which particular thing you say?
Nothing has been followed, my lord. In this,
what has been not been followed?
you
You are a temporary government servant,
yes,
and it is stated that this is to be followed. That is there in the appointment letter. That is there.
yes, ma'am.
So, which according to you, that does not indicate that anything like before terminating this, some evidence is to be recorded. All these things that is not there. Only you are to be given as it appears. A notice has to be sent, and you are to be given an opportunity to file your show cause, and then the authority has to decide. So you are advancing an argument that since it's a major penalty, all other procedure as laid down for the regular employees, that is to be followed. Where is that in that rule?
No, that in this appointment letter, 65 rules has been mentioned, my lord. That temporary service rules, my lord. And
that is why we are asking you. Said
yes,
that you have put
and in this manner they have stated that the 1 month salary, and that has not been given.
Where
That
have you
has been
pleaded? Where have you pleaded?
that then they have admitted that it is not needed as per the clause 7 of the
Correct. You
appointment
can't
letter.
expect that equity. He who seeks equity must do equity. Where is the equity from your side?
My lord, on clause 7, on lieu of clause 7, they have not followed
It
the
is
rules.
outrightly to be taken.
Clause 7 of this appointment letter, my lord.
No, you said that that has not been followed, but in what way that has not been followed, you have not stated.
And tribunal also stated that that need not be followed as per the appointment letter manner.
Be happy that no criminal proceeding has been initiated against you so far.
No, that is admitted, madam.
No,
No.
what admitted?
That is a criminal proceeding was there.
No.
No.
Basing on the information given.
No, I have not informed. I have admitted.
No. It is good that the authority has not proceeded against you in criminal side.
They may also take steps for recovering the entire salary which has been paid to you. That is also likely to happen. So that has not happened. It is well and good. So be satisfied whatever you have got. Take down for the learned counsel for the petitioner, learned counsel for the state. The petitioner, yes, the Binod BC Union of India. The petitioner Binod BC has filed this writ petition challenging the order dated 16/8/2018, Annexure 6, by Annexure 6 passed by so and so, and the order dated 29/8/2024 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00408 of 2018. In dismissing the original application, it appears that the petitioner preferred the original application before the London Tribunal to set aside the order of termination dated 16/8/2018 with a further direction to the respondents to permit him to continue the work till disposal of the criminal appeal on provisional basis, and also to set aside the order dated 2/1/2023 passed by the Superintendent RMS and Division Cutter. The petitioner was arraigned as an accused relating to an incident which took place on 29/3/2009 for offense punishable under section 302 of the Indian Penal Code and other offenses. And he faced trial in the court of London Additional Session Judge Sonpur in S number 10/35 of 2000, along with 28 accused persons on being charged under section 147 so and so. And by judgment and order dated 13/2/2004, though the petitioner was acquitted of other charges, but he was found guilty under section 323/149, 324/149, and 325/149 of the Indian Penal Code, and sentenced accordingly. Against the aforesaid judgment and order dated 13/2004, the petitioner preferred an appeal before this court in CRLA number 49 of 2004.
during the pendency of the appeal, the petitioner was appointed as what was your post?
MTS, multitask staff. MTS, multitask staff.
Multitask
MTS, multitask staff.
Staff.
multitask staff in the office of
Chief Postmaster.
Senior Superintendent RMSN Division, Cuttack. While the appointment later dated 14/3/2018 लिखिला under Annexure 2. And in the prescribed form submitted before the authority, the petitioner did not mention that any criminal case has been pending against him, and much less he has been found guilty under section 323 by 149, 324 by 149, and 325 by 149 IPC by the Learning Trial Court. The appeal preferred by the petitioner was decided finally by this court, and by judgment and order dated 12/5/2022, this court confirmed the judgment and order passed by the Learning Trial Court and dismissed the appeal. Thereafter, the petitioner preferred specially petition before the Honorable Supreme Court, and on the basis of such specially petition, CRLA number 1802 of 2022 was registered, and the Honorable Supreme Court, by order dated 18/10/2022, also confirmed the conviction of the petitioner under the aforesaid offences. However, so far as the offense under the sentence under section 325 by 149 of IPC is concerned, taking into account his physical disability, the court, the Honorable Court reduced the sentence to period already undergone. While the matter was sub judice before this court, the petitioner received a show cause notice from the authority for suppression of facts in the attestation form with in relation to his provisional appointment. And there the authorities have mentioned that the petitioner has furnished false information, and there has been suppression of factual information in the attestation form, and on getting the show cause notice and on receiving the show cause notice, the petitioner furnished the reply, and the authority, after carefully going through the so-called reply filed by the petitioner dated 30/7/2018, held the same to be not convincing, and further held that the petitioner has mentioned no and N.A against all the subparas of para 15 in the attestation form, for which it is proved that he knew everything while submitting the attestation form. And the petitioner has also given an undertaking in the attestation form that he was fully aware that by providing false information or suppressing material information while filling this form, filling the form, the authorities would have full right to terminate his appointment later, and he would be liable for appropriate criminal or civil action as a consequence. And the authority was of the view that in view of the warning section in the attestation form, and the suppression of fact committed by the petitioner, he deserved appropriate criminal or civil action. And accordingly, it was ordered that the provisional appointment be terminated with immediate effect. The petitioner challenged the said order before the Central Administrative Plan and Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260 oblique so and so, so and so. And during the pendency of this of the original application, the not only the judgment of the criminal appeal, but also the order passed by the judgment of this one, so by this court, so also the order passed by the Honorable Supreme Court in criminal appeal number so and so came to fore. The London Central Administrative Tribunal, after considering the submission made by the London Council for both the parties and taking into account the provision in Rule 5 of the Central Civil Services Temporary Service Rules 1965, has been pleased to hold that at the time when the petitioner submitted his application, criminal case was instituted and pending against him. The petitioner was also arrested and detained in judicial custody, and he was released on bail by the order of this court. And admittedly, he has suppressed such fact while submitting the application oblique in the attestation form, which came to notice after police verification. The London Tribunal also took into account the judgment pronounced by this court in CRLA number 49 of 2004, dated 12/5/2022. So also the order passed by the Honorable Supreme Court in the Criminal Appeal number 1802 of 2022. And has been pleased to hold that the petitioner has himself admitted that he did not disclose in the attestation form about his involvement in the criminal case out of fear of his automatic disqualification. And if the petitioner would not have suppressed the same in his attestation form, he might not have been selected, and in his place, another person would have taken the berth. And the petitioner has not come with clean hand, and therefore he is not entitled to equity. The very approach and intention of the petitioner is proved to be ulterior, and therefore his termination from service is based on rules after giving him show cause notice and as per the conditions stipulated in his offer of appointment, no lenient view in the facts and circumstances can be called for. Mrs. Madhumita Panda, learned counsel appearing for the petitioner, drew the attention of the court to the grounds taken in the writ petition challenging the impugned judgment impugned order passed by the London Central Administrative Tribunal, which are as follows for the grounds taken in the paragraph number 18. The main attack of Mrs. Panda is that the authorities have not followed Rule 5 of Central Civil Services Temporary Service Rules 1965. The same has been quoted in the writ petition. After going through the same, we do not find that how the authority did not comply to the said provision. The authorities have issued show cause notice, and the petitioner has filed his reply, and after going through the same carefully, particularly in view of the admission of the petitioner that he did not disclose in the attestation form about his involvement in the criminal case out of fear for his automatic disqualification. We are of the view that the authorities have rightly terminated him from the service, and the Lenin Tribunal has discussed everything, and after taking the contentions from the respective sides, has passed the impugned order. We find that there is no illegality or impropriety in the impugned order. Therefore, we are of the view that the writ petition being devoid of merit stand dismissed. Yes.
Item number 10.
On disbursement of land acquisition award, similar order, your lordship has been passed earlier.
Give it to you.
Item 11.
May I please, Your Lordship?
Yes.
Lordship, all the matters are covered matters in item number 11.
Please give the order. Have you given the copy of the order?
Attached in the
Written in under annexure 2.
Annexure 2 వచ్చి same order pass disposal.
Item 12.
Yes.
May I, Lord of the
Yes, Mr. Mahanti.
Yes, the petitioners are landowners. The prayer is for early disbursement of the compensation amount together with interest, which is about 54 lakhs and lying in deposit of Civil Judge Senior Division Bhubaneswar.
The proceeding is still sub judice there.
My lord,
Proceeding is still sub judice there, or it has been disposed
the
of.
proceeding is LA case is still pending.
Okay. You want that particular case to be disposed of at an earliest.
Disposed of and
What is the case number?
49.
You have not
49 of 2015.
LA case number
49 by 2015.
49 of 2015.
Prayer କିଛି ଲେଖିନା ଥିବ କୋଉଠି ଲେଖିଛନ୍ତି reproduction
Annexure 3, page 23.
annexure 3.
No, that's there, but prayer is not.
My lord, may I make a little more?
Yes.
My lord, the compensation amount has been adjudicated, lying in deposit, not in dispute, and lying in deposit since 2018. But the further point of law will be the award has not been passed within 2 years from the publication or notification under section 6(1). So therefore, the acquisition proceeding had lapsed under section 11A of the Act.
No, now you want the disposal of the case because it is almost 10 years of
Yes.
going to. So we are directing it to be everybody has appeared and there is no problem in that way. There is no stay order passed.
No stay order.
This writ petition has been filed inter alia for a direction to the Civil Judge Senior Division Bhubaneswar in LA case number 49 of 2015 for early disposal. The Land Council submits that almost 9 years have already passed and the compensation amount has already been deposited. It is
The annexure 1 itself will indicate
In a
that
disputed fact, they deposit
and therefore unless necessary direction is issued to the concerned court to take up the matter expeditiously, the petitioner is seriously prejudiced. The Land Council for the state has no serious objection to such prayer, considering the limited nature of the wants of the petitioner. And since the LA case is pending since 2015, we direct the Land Swanso to expedite the hearing of Swanso and dispose of the same within a period of 15 months. ବେଶୀ ତା ଦେହରେ କମ୍ପ୍ଲିକେସି ଅଛି କି
ନାଇଁ କିଛି କମ୍ପ୍ଲିକେସନ ନାହିଁ
ମାନେ 3 ମାସ ଦଉଛୁ ସେଇଠି ଏକ୍ସଟେନସନ ମାଗୁଛୁ ମୁଁ ସେଇଥିପାଇଁ ପଚାରୁଛି ଆପଣ ଜାଣିଥିବେ ନା ମାନେ
କେବଳ ଖାଲି ମୋ ଜାଣିବାରେ ଯେ ଗୋଟେ ୱାନ୍ ଅଫ୍ ଦି ଅପୋଜିଟ୍ ପାର୍ଟି ତାପରେ କଣ ସର୍ଭିସ ସଫିସିଏଣ୍ଟ ହେଇନଥିଲା ବୋଲି ତଳକୋଟରେ ଗଡୁଥିଲା ସେଠି
from the date all the opposite party and
yes. Otherwise, how can say it?
I will ensure because he is also one of the petitioners here.
After all the opposite parties enter appearance. Yes, next.
Well, this
3 months time here.
The order may be communicated to the trial court at my cost.
No, you find the certified copy. This the learned Swanso shall act upon the filing of the certified copy to be produced by the petitioners.
And the learned trial court shall rely on that.
Oh, obviously, certified copy. Yes. Next.
Item 13.
My lord, in this case, your lordship have already decided one matter where the affected person has been awarded with land acquisition compensation. Because here in this case, my vendor has been awarded with the land acquisition compensation, whereas my registration is prior to the acquisition of the land, my lord.
No, no.
Your
What
lord.
is your prayer in this petition?
My lord, here, what has happened, my lord, the land acquisition compensation has been decided and it has been given to the vendor of my vendor, petitioner's vendor. Those real legal heirs of that original vendor is 5 to 10. My lord, after that, I made a representation to the authority saying that I am the rightful owner of the property which has been acquired.
Yes.
But the authority did not listen to me. Thereafter, I approached your lordship. One of the affected person approached. Your lordship have decided this, my lord.
Okay.
Directed
In
the
another
opposite
case,
parties.
similar
Another
case.
similar, same my lord, acquisition and the area is also same.
Where is that order?
My lord, your lordship.
Yes, yes.
I have not seen the
No,
copy.
no.
Ah, yes.
See that order. That verify whether
Verify.
ultimately what direction we have issued.
Your lordship directed the opposite parties to pay that because notices have been issued to me as well as to the that legal heirs of that original vendor. Those who have received the acquisition amount, my lord. Both of them appeared. But since no effective steps were taken for recovery of that amount and to hand over the
Another person received it. In
my
your
lord,
case, that has not
and
been.
yes, here also opposite part number 5 to 10 they have received. In that case, one vendor was there, but here the original vendor died and the legal heirs they have accepted.
They have received it.
My lord. Same, my lord. Identical.
How can we?
Hearing them, how can we pass such order? If you say that
My lord.
that C.Sahoo
Yes.
has sold you that land, particularly, and therefore the legal heirs of C.Sahoo are not entitled to
Yes.
My lord.
Can we
the
say?
compensation
My lord.
amount, and because of that deed,
Yes.
say,
Unnecessary.
so without hearing them, how can we?
So, lordship, direct my learned state council to obtain instruction as to what is the exact amount of that.
Notice has to be issued. You have made them parties rightly.
My
So
lord.
they are to be noticed. You cannot.
As your lordship.
Relying on this judgment, we cannot pass. This
Same
is
fact.
of the admission stage.
Yes, your lordship. As your lordship.
My lord, I have one point to say. I am appearing for opposite party number 1.
Yeah.
Actually, opposite party number 1 should not have been made a party. In his place at a GM Railway, East Coast Railway should have been made a party. The Secretary Railway Department, my lord, in New Delhi, they have nothing to do here, my lord.
It's the construction of the doubling of the Daitari Banspani railway track.
That amount must have been deposited with the authority, and they must have. That is how that
the state authority.
State authority.
But I am. Secretary is not the necessary party. He is an
X or Y. That is the lookout of the. So why unnecessarily he says that is no way. They have deposited the amount.
Yes,
before this. So you delete. There is
I'll delete. I'll file a memo.
Appearance in this case, appearance may be noted so that.
Just give the name.
Yes.
Submits that the opposite party number 1 is not a necessary party. Land counsel for the petitioner also accepts the submission of the land counsel and files a memo that the name of opposite party be deleted. One be deleted from the one. So prayer is accepted. This writ petition has been filed with a prayer, no so and so. It is the contention of the land counsel for the petitioner that the petitioner has already purchased the land in question, which was acquired by the authorities from C.Sahoo by way of registered sale deed.
Registration.
And therefore, he is entitled to get the compensation. But the legal heirs of the opposite that C.Sahoo has received the compensation, which was not proper and justified.
issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Learned counsel for the state accept notice on behalf of opposite parties number 2, 3, and 4.
My lord.
Requisites for issuance of notice for opposite party number 5 to 10
My
shall
lord.
be filed within a week,
My lord.
right?
Yes.
This matter of 4 weeks after. Counter affidavit, if any, be filed in 8 or from the 8 of the learned counsel for the petitioner submitted that in a similar case in WPC number 1, an order has been passed. The order is taken on record. They're just coming with it.
Item 14.
Here the petitioner is challenging the auction.
Just a minute. Okay. Just a minute.
The petitioner is challenging the auction. Auction notice dated at page 11, Annex 1, to be held on 29th of November.
Go to the DRT.
Earlier, my lord has passed the similar order
In another loan account.
on 18/10/2024.
Next.
Obligation, my lord.
Item 15.
ଆପଣଙ୍କର ନାଁ ଦେଇଦେଲେ ତ ଯୋଉ ବ୍ୟାଙ୍କ Yes, 15, item 15.
Please, your lordship. Similar order passed.
Representation annexure 4.
Yes, ma'am.
ये तीन का कुछ है?
Same.
15, 16, 17.
Yes, ma'am.
Maloj, may I request Maloj, let him file a fresh request because it is 2019 representation.
19?
Yes, ma'am. And the proof is also not there. My learned senior may file a fresh representation.
All right, let it on to
2020.
The representation is of the year 2019
and 20.
And 22. Let him file a fresh representation within 2 weeks from today, and the same shall be disposed of. But here also 3 months or 2 weeks later that period. Yes. That is in item number 15, 16, and 17. All right. Yes.
Item 18.
Please, your lordship.
Urban Cooperative Bank, you are appearing.
You are in 19, we are in 18.
May I please, your lordship? Your lordship, I'm appearing for the petitioner in this instant matter. The petitioner is the auction purchaser, is aggrieved by the violation of the basic principles of natural justice by the learned DRT, and being adversely, for that reason, that order has adversely affected the right, title, and interest of the petitioner. I am challenging the order that has been annexed in Annexure 4 and Annexure 6 of the instant petition. Your lordship, the petitioner.
What is Annexure 4?
The order of the learned DRT, wherein the learned DRT has passed an order without according a chance of being heard to the petitioner,
when that order was passed?
In the year 2008. In the year 2017, your lordship.
What you are doing?
Your lordship, I will just submit the limited facts of this case.
What you are doing for last more than 7 years?
Yes.
What the other order you are challenging?
Then the same order was challenged by the opposite party number 1 and 2 via a miscellaneous petition which has been annexed in annexure number 5. The order was passed in the year 2017 and the order is annexed in annexure number 6. Your lordship, subsequently we were writing a lot of letters to the.
What is annexure 6?
The order passed by the learned DRT, wherein again the learned DRT held that the cancellation of the sale certificate that was issued in favor of the petitioner, and the petitioner, after enjoying the possession of the property for good 2 years, the possession should be
filed after the dismissal of your that application, essay application. That was dismissed in what was done in that submission, learned and council ever mentioned so and so.
Dismissed. MA.
MA dismissed. Appeal is allowed. Notices under so and so are quashed. So then what happened?
Your lordship, we were not aware of the present case. We were only. It was brought to our.
Just a minute. This when this annexure 4.
Yes, your lordship.
There, as it appears, the Orissa concrete products.
Yes, your lordship.
He was the
original owner, opposite party number 5 in this instant
Right.
matter.
He challenged the sale notice.
Yes, Your Lordship.
Okay. So sale notice was challenged, and you must have been added as opposite party or the defendant.
Your Lordship, we were not added as the opposite party.
So where is that essay application?
The essay application, the order of the essay application.
No, essay application.
Your Lordship, the essay application has not been annexed. However, the MA application that challenged the essay application has been annexed in annexure number 5.
No. Here you please come to the page number 27, annexure 4. You see for defendants number 1 and 2, Mr. R.K. Koro is appearing. So R.K. Koro is appearing. The defendant number 1 is the bank.
Yes, Your
authorized
Lordship.
officer. Who is defendant number 2?
The defendant number 2 is the branch manager of the Urban Cooperative Bank, Jajpur. Your Lordship, there are two opposite parties.
So you are not been added as a opposite party?
No, Your Lordship.
Just a minute. So by the time this essay was filed, that sale notice was challenged. So when that sale was confirmed?
On 21 of 2014.
21
date.
20th of January.
21/12 of 2015 was the date on which the sale was confirmed in the name of the
certificate was issued.
The sale certificate was issued.
2015.
Yes, Your Lordship.
Just a minute. 21/12/2015.
It is on annexure number 3.
Right, annexure number 3. So this order when this order was passed by the London DRT?
Your Lordship, the first order, that is the essay order, that was
essay order was passed on
in 2017.
No, where is the date given?
1 February 2017. Your Lordship, it is annexure number 4.
Annexure 4 date ta kodi
Date ta
mention
kodi
nahi
achi.
Again.
No, date of delivery of orders, it is 1st of February 2017. Just below essay. Date of delivery of order 1/2/2017.
1/2/2017. So by that time, the sale certificate has already been issued.
Yes, Your Lordship.
So nobody pointed out that such a what is the contention of the bank then? Let us see.
Your Lordship, the bank has filed multiple.
Come to paragraph number 3.
Yes, Your
Of
Lordship.
the annexure 4. For the bank appeared to the council, did not file any written statement. Acha. So notice was
But
issued.
respondent 1 and 2 had filed caveat. Accordingly, notices as issued.
Did not file लिखा है जी paragraph 3
Did not file so far.
क्यों आपसे सुनेगी नहीं और
Not counsel for the applicant only.
After that order was sale notice was set aside. By that time, this sale certificate has already been issued. Then MA was filed by whom?
By
MA
you.
was filed by the bank itself.
Bank.
Was filed.
Again by the bank. And Your Lordship,
That was filed in 2017.
yes, Your Lordship.
389 of 2017.
389 of 2017. What was the stand taken by the bank then?
Your Lordship, before that, if I could point out, even in page number 31 of the same judgment also, the negligent act of the bank was also pointed out by the...
No, we have seen that.
Yes, Lordship.
We want to see that in 2017,
Yes, Your Lordship.
when that miscellaneous application was filed,
Yes.
In that disposed of essay,
Yes, Your Lordship.
what was the stand taken by the bank? Because at the earliest time, they filed entered appearance but did not file any show cause and did not was present also.
They prayed for recall of the final order in essay.
Yes, Your Lordship.
That was a recall of the order. challenging the sale notice published by the bank on 24/11/2015 on the ground of material suppression of facts by the opposite party causing hardship and prejudice to the auction purchaser.
Your Lordship, the same was dismissed by the learned DRT on the grounds of two reasons: that it was limited by, it was barred by limitation, and the second was the contention taken was the land was an agricultural land, and for that reason the provisions of Surfacy Act will not apply to the present case. For giving these two reasons, the learned DRT dismissed the case.
Come to the operative part of that.
It is on page number 49.
Page number 4.
It's a chunk,
No, you come to the page number 53. Page number 53.
Yes, Your Lordship.
Last paragraph.
Yes.
As regards mortgage.
You come to that this tribunal vide order dated
18/12/2015.
No, this tribunal vide its order dated 18/12/2015. Read it out. Yes.
18/12/2015 directed the appellant / opposite party to deposit 10 lakhs with the respondent bank on or before 21/12/2015, and in case the applicant deposits the amount, the respondent bank is restrained from making further steps on the sell notice dated 23/11/2015. It is further directed that in case the applicants fail to deposit the amount, the respondent bank is at liberty to auction the property as per law. This tribunal, while passing the aforesaid order, no objection was filed by the respondent bank. This tribunal gives ample opportunity to file objection, but the respondent bank failed to file their show cause and also failed to prove their case, and this tribunal, after hearing the counsel for the applicant and the respondent and on perusal of the records, has passed the order dated 1/2/2017 on merits, and the respondent bank filed this petition after more than 2 months of the final order dated 1/2/2017, which is barred by limitation also, and no limitation petition is also filed, and no reason has been assigned for the delay.
Just a paragraph before that, as regards the mortgage property, it is evident that the property is an agricultural property. ROR published in such and such shows agricultural land. There is clear provision in section 8A Orissa Land Reforms Act. No agricultural land. What is all that? Not visible. Mortgage also goes in any case without hearing that what.
Now the thing is that this both the order goes against you.
Yes, Your Lordship.
And there is appeal provision against the order.
Yes,
so
Your Lordship.
any person agreed by the order passed by the DRT can approach the DRAT.
Yes, Your Lordship.
Right. So why have you not approached the DRAT? Why have you come to this court?
Your Lordship, because I'm seeking equity, before answering this particular question, I would like to disclose that a writ petition was also filed by the opposite party number 1 and 2 before this honorable court, which was again dismissed against the right of the party, and on basis of that, a revision petition is also pending, which is ongoing, which has almost the same cause of action. Your Lordship, we have filed this writ petition because, Your Lordship, in the learned DRT case that was filed before the learned DRT, we were never made the party. We were not aware of the existence of the case, and without being the party of the case, we cannot go for an appeal to the said order. And Your Lordship,
that provision.
So the writ petition which was filed before this court in WPC 15886 of 2019.
Yes, Your Lordship. The first writ petition number is.
There the stay order was there.
No, Your Lordship.
No. Illegal order passed by this in violation of settled law in disrespect of the direction of the Honorable High Court. Though by order dated 19/9/2019, the Honorable Court was pleased to grant stay on the aforesaid orders of DRT in disposal of IA 12189 of 2019. The writ petition was abruptly dismissed by subsequent order dated 27/2/2023. advising therein to go before proper forum.
So, madam, please come to section 18.
Yes.
You made a submission that if you are not a party before the DRT, you cannot challenge the order before the DRT. Come to the provision under section 18 of the Surface Act.
Section 8, exemption 18.
No, we are asking you to come to section 18,
Yes, Your Lordship.
which deals with appeal to the appellate tribunal. Are you having that book with you?
Yes, Your Lordship.
Please
Appeal to appellant tribunal.
Yeah.
Any person aggrieved by any order made by the Debts Recovery Tribunal under Section 17 may prefer an appeal along with fees as may be prescribed to the appellant tribunal within 30 days from the date of receipt of the order of the Debts Recovery Tribunal, provided that different fees may be prescribed for filing an appeal by the borrower or by the person other than the borrower. Provided further that no.
It's all right. Where is the provision that somebody who is not a party before the DRT, he cannot come within the definition of person aggrieved and he cannot prefer an appeal before the appellate tribunal. In this case, you are admittedly not a party before the DRT, not you are a party in that MA, but you are a person aggrieved as per what your submission. So why don't you directly approach the DRAT, and why did you make a submission that since I am not a party before the DRT, so DRAT may not entertain my appeal?
Your Lordship, firstly, humbly, I would like to submit that the petition that was supposed to be the appeal petition is already barred by the limitation.
You can file that application for condonation of delay and satisfy the appellate court that under these circumstances, when I am not been a party before the DRT, I am kept in total darkness. Now I am coming to, so that delay may be condoned. So the appellate authority can consider it. But the proposition which you are advancing
Indeed.
for approaching this court directly without taking recourse to section 18 is that I was not a party there. So even if I file the appeal under section 18, that may not be maintainable. So that is why you are approaching this court. That means in spite of availability, that alternative remedy cannot be applicable to you. So satisfy us on that point that a person who is not a party, even if he is a person aggrieved, cannot approach the DRAT directly.
Indeed, Your Lordship. Your Lordship, I would like to most humbly submit that even though an alternate remedy is available, but however, it has been upheld by plethora of cases that an presence of an alternative remedy does not restrict.
We are not on that point. We know that even if alternative remedy is available, this can be done.
Yes, Your Lordship.
Since you are advancing an argument on that, making a submission, so have you any authority with you that a person who has not availed the DRT cannot oppose the DRT? If you are not prepared, get yourself prepared. We can take up this matter tomorrow. There is no
Indeed, Your Lordship.
problem.
I'll do my research.
Will you be comfortable if we take this matter tomorrow, or you want
Yes, Your
some more
Lordship.
time?
Yes,
Tomorrow.
Your Lordship. I'll do it.
All right. The petitioner Messrs. Sri Bimal Oxygen and Minerals Private Limited, represented through the Bimal Kumar Agrawal, Director, has filed this petition challenging the order dated 1/12/2017 passed by the London DRT, Debt Recovery Tribunal, Cuttack, in essay number 68 of 2015. So also the order dated 24/7/2019 passed by the London DRT, Cuttack, in MA number 389 of 2015. The it appears from the impugned order under Annexure 4 that Messrs. Orissa Concrete Products filed the said essay against the bank, challenging the sale notice dated 24/11/2015 and the purported possession notice dated 16/3/2015. The London Tribunal, by order dated 1/2/2017, has been pleased to allow the appeal and quash the notices issued under Section 13(2) and 13(4) of the Surface I Act. The said order, the bank filed MA miscellaneous application number 389 of 2017 for recalling the order dated 1/2/2017 passed in SA number 68 of 2015, which was dismissed by order dated 24/7/2019. The case of the petitioner is that he is the auction purchaser and sale certificate has been issued in his favor on 21/12/2015, but neither he has been arrayed as a party in SA number 68 of 2015 nor in MA number 389 of 2017. The Land Council submits that since the petitioner is a necessary party in as much as the sale certificate has been issued in favor, but neither he has been arrayed as an party to the proceeding nor given opportunity of hearing. Therefore, the orders passed by the London Tribunal is not sustainable in the eye of law as it suffers from principle of natural justice. When you put a question to the London Council for the petitioner, give your name, London Council, that since the impugned orders passed by the London Debts Recovery Tribunal against the so and so, an appeal can be filed before the appellate tribunal under Section 18 of the Surface I Act. Why the petitioner has not availed such a remedy? The contention of the Land Council for the petitioner is that since the petitioner was not a party in the before the London DRT, either in SA number so and so or in MA number so and so, his appeal may not be entertained by the London Appellate Tribunal, even though the provision is very clear that any aggrieved person can prefer an appeal against an order passed by the Debts Recovery Tribunal. She seeks time till tomorrow to place certain citations on this aspect to show that even if alternative remedy is available to the petitioner under the peculiar facts and circumstances, this court can exercise its power under Article 226 of the and 227 of the Constitution of India. List this matter.
Much obliged, Your Lordship.
Rest of the matter.
Item, next item.
Will you come tomorrow?
Only, my lord, pray, my lord, I am for the petitioner. Here, my lord, I have filed rejoinder to the counter filed by the auction holder. Madam, customer appears for bank. No counter copy has been sought. Lordship may fix a date and let direction be given to. Hey, can you supply the counter copy so that the man can file the counter? We're ready.
I have supplied copies, counter copies, my lord.
Alright, the counter affidavit is available on record.
Yes, my lord. Date.
You do one thing, you collect it in your pen drive.
My lord.
Ryan also not the auction purchase. Keep your pen drive, collect it. Madam is saying that it has already been served on the previous council. Now it is available, you take it. There is no problem.
Date chart.
Next week, fix a date so that it can be.
WPC number show the land and council for the petitioner. So also the land and council for the
I am for the petitioner, my lord. Mr.
Petitioner, and you are for
the auction for OP4.
Opposite party number 4 submits that the counter affidavit filed by the bank has not been served on them. Stop. Let the land council for the so and so be permitted to take the copy of the soft copy of the counter affidavit in their respective pen drives. Registration supplied.
Let it come Monday, my lord, 25th.
Matter to be listed next week.
25th.
Basic file is scheduled for 2 weeks time again.
Okay, he wants to file a reason affidavit.
Opposite number 4.
Opposite party number 4 is this matter on 9th of December.
Nine of the today's list, my lord. And earlier mentioned, and the state council is also ready with the matter, my lord. If that could be taken up for you.
Let the orders matter. We finished that.
Mine.
Is the memo, my lord? The appellant is in custody since the last 18 years.
Supplementary list item number 1.
The one there, my lord, who Usarani Padi name is appearing. But
That is
she has joined in the state panel.
Yes. Yes. Next.
Item number 2.
On behalf of Mr. Patnaik, paper book may be supplied.
Paper book is not ready.
Appointed by court mail.
That's all right. Who is to argue this matter?
Mr. Patnaik.
Romani Patnaik.
Romani Kanta. Romani Kanta. Romani.
The jail criminal appeal of the year 2015, as it appears, paper book has not been prepared. Let the registry prepare the paper book within 4 weeks and supply a copy of the same to the Land and Council for the appellant. The name of the Land and Council for the appellant be correctly reflected in the cause list आज रमणीकांत पटनायक है ना, KANTA तो also the state. Yes, next.
Item number 3.
Item number 3, my lord, I am appearing for appellant number 4, 6, 8, and 9. But in the meanwhile, appellant number 8 is dead, my lord.
So
The lordship
report from
directed to obtain instruction.
That instruction is not I place on time.
And what about that bail application is there?
My lord, I am
3 and
appealing for
5?
the appellant number 3 and 5, my lord.
Yes. So, whether the earlier bail application was rejected or
My lord, your lordship has granted the interim bail, my lord, for a period of 3 months, my lord. They have surrendered, my lord. I have also filed the surrender certificate.
when the last time you were granted bail?
Last time, my lord, he was granted bail.
Number 3 and 5.
My lord.
When they were granted bail. Okay, perhaps that is 27 to 2024.
My lord.
They were granted interim bail for a period of 4 months.
4 months, my lord.
Then you have surrendered.
My lord, I have surrendered, my lord. I have also filed the surrender certificate.
Okay.
On 19/7/2024, my lord.
1, 4, 6, 7, and 9 was rejected earlier, and interim was given subsequently. 8 has expired.
Right.
8 has expired, and the other persons, my lord, other applicants, my lord.
No, order dated 16/9/19. There it was rejected in respect to 1, 2, 4, 6, 7, and 9.
2 is also, it has mentioned that abated.
2 is abated.
2 is abated.
One died.
Now, so far as today this is concerned, we have to consider the
3
and 5, IA number 2543. That is one thing. The other thing is that the instruction so far as that
8.
Death of appellant number
8.
8, that you want to take time.
Right.
What about the conduct of this two appellants when they were released on interim bail? As for the order of this court dated 27/2/2024, have you brought?
No, that letter was issued twice, but no response has been made.
That was for 8. Letter was issued.
No, 8 and others.
Shall not indulge in. The bail was granted. Now we had given direction to obtain that sometime in 27.
So who is not responding you?
No, that so far the 8 is concerned. They have Superintendent Police Sundargarh letter was issued. Last letter was issued on 1/10/2024. That we have to obtain instruction.
No, what about this? He has filed an bail application for appellants number 3 and 5.
That was on 27/8/2024. Mr. Vishwajit Naik, learned counsel for the appellant 3 and 5 filed surrender certificate or 27/8 there. Then on 10/9/2024, learned counsel for the state submitted that instruction has been sought for. 10/9 रे आपण मागितले से आसीने पण
ये को आईआईसी कौन है? ये आपको रेस्पॉन्स
letter was issued IIC Boni.
That is regarding to Miller death of the opposite part number 8.
No.
The
3 and
status
5.
of appellant 178. That is letter, sir.
1 died.
3 and 5 I may allow some time. That so all the letter corresponds to appellant 1, 7, and 8.
No, we are now
3 and 5.
3 and 5 रो conduct कौन मिला? ये विषय हम जाने.
That is not available. I
सेटा मैं कोई नहीं तो.
Item number 272543 of 25. This is an application for bail of appellants number 3 and 5. As it appears, both these appellants were directed to be released on bail, interim bail, for a period of 4 months, as per order dated 27/2/2024 in IA number 2923 of 2023, and after availing the same, they have surrendered in the trial court, and the London Council for the petitioners have filed the surrender certificate, which is on record. Let the London Council for the state obtain instruction regarding the conduct of the appellants number 3 and 5 while on interim bail. Out of this matter, good saptah par rakhibe.
Minute custody certificate. Custody certificate.
To also to produce the custody certificate. Baki order lekhi jantu. Main application CRLA report. CRLA number 1. The London Council for the state seeks some further time to obtain instruction regarding the death of appellant number 8 का नाम देखिए लिख दे है ना सुजन नायक है ना फिर झारखंड एटा तो ये आपनकर एसपी सेटिकार एसपी को कम्युनिकेट करिवो सिमडेगा झारखंड है ना गोटे सप्ताह छाड़
No blessed.
Item 4.
My power is there because that the brother-in-law was facing a content proceeding before your lordship. Thereafter, the appeal on that day, the concerned counsel for the appellant submitted before lordship to appoint any other counsel. For that, my power is there. Content proceeding, my power. I was appointed by the legal aid.
So that is over since
my name may be deleted.
When the CRLA, we had passed an order.
So now, who is appearing for this in the CRLA?
My lord, to my knowledge, on that day, the concerned counsel for the appellant stated before your lordship that my name may be deleted.
Nityananda Panda.
My lord, my
lord.
I will look in. It's not there.
Filed an affidavit also.
No, it is there. Mr. Nityananda Pandal and counsel for the appellant submits that he does not want to continue. It's CRL 389, page 9.
In late intimation be sent by registered official of this court to the London trial to intimate the same. To appellant Giotto alias Sonathan so that he can also be appeared if he is unable to check
As in a report. A report has
prisoners. 3/10/2024 ନିତ୍ୟାନ୍ତ ପଣ୍ଡାକୁ ଦେଇଥିଲି କିନ୍ତୁ ଦୁଃଖର ଶୁଣାଂଶ କେସଟି ବି ଛାଡ଼ି ଦେଇଛନ୍ତି ମୁଁ ଏକ ଗରିବ ଆଦିବାସୀର ନିଯୁକ୍ତି କରିବା ପାଇଁ ସରକାରଙ୍କ ତରଫରୁ prisoners petition dated 3/10/2024 wherein request has been made to engage counsel from the legal and planning the name of other counsels are not being reflected only for it. Yes, next.
Item 5.
You made a submission that he's in custody since
yes, my lord.
22/12/2015.
Yes, my lord.
And the state took time to obtain the custody. Yes.
Reply not received.
Which jail constable. Superintendent. Superintendent Jail Panjam. Panjam. So let it bring it next week. We can take on minor. The Lions Council for the state. 6 for an adjournment. And it order pass alani 4-11 रो. So upon already 15 days pass करिए रानी. But twice the letter submits that is yet to obtain the custody certificate as per the order dated 4/11/2024, and the matter may be taken up next week. Since this matter will commencing from 25th November. Yes. Okay.
Item 6.
Item 6, my lord. Last occasion, my lordship directed.
On last week. Conduct of the petitioner while on interim bail. Yes,
That has not been received.
Get it next week. Same like the conduct report not received 25/11. Next.
Item 7.
Passover the hearing around which Passover. Next week.
7. Next week.
Item 8.
Yes.
Item 8. The TCR has come once.
No, paperwork is ready.
Yes, ma'am. Paper.
So Ashok Kumar Das is supposed to argue the matter. So he was engaged from the panel.
He is on panel. Ashok Kumar Das. No, it am lekha hai. Oh, he is in the panel to conduct the appeal. He should be there. He didn't come. Change kar do. We'll change it.
Change kar do. Yes, next.
Item 10.
9.
Item 9.
Mr. Lordship, measure prefer one captive. The prefer one captive replacement.
Item 10.
Judgment of. Six years. 6 years होने आकर से जानू नहीं ना जेल वाला वेलफेयर अफसर कौन सी it is sheer negligence. Absolute negligence. जो दिनों से जजमेंट हला तार दिनों तो बोटे
अब जजमेंट कॉपी दी थी ना तो
original petition or reclamation केवल
ये लोग कुछ आर्थिक अभाव जो अपील करे चाहूँगा जी
अच्छा पहले तो एंगेज कर लो
पहले तो हम कर लो पेरेंट्स so and so the stamp report was pointed out that there is delay so and so that since it's a jail criminal appeal and the petitioner has been sentenced to life imprisonment for offense on the section 302 in filing this appeal is condoned and admit for the trial court report. Prasad Dev present this court. Yes. Irradiation.
16.
Kali. This is Judge.
Wait.
Kindly unmute.
Admit him.
Unmute the mic.
Judgment.
Ongul Central Jail. Unmute the mic. Asli.
ପ୍ରକାଶ ବେହେରା କିଏ? ଆଉ ନନ୍ଦକିଶୋର ସେଠୀ? ହଁ, ଆପଣଙ୍କୁ ଯୋଉ ଆଡିସନାଲ ସେସନ ଜଜ ଅତିରିକ୍ତ ଜିଲ୍ଲା ଦୌରା ଜଜ ଆଠମଲ୍ଲିକ 27/9/2024 ରେ ଯୋଉ ବିଚାର କରି 302 ଦଫାରେ ଯୋଉ ଆପଣଙ୍କୁ ଫାଶୀ ଆଦେଶ ଦେଇଛନ୍ତି ତା ପାଇଁ ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ ଅପିଲ ଫାଇଲ କରିନାହାନ୍ତି। କେବଳ ଯୋଉ ଆଇନ ଅନୁଯାୟୀ ଆପଣଙ୍କର କେସ୍ ଟା ଡେଥ ରେଫରେନ୍ସ କେସ୍ ଏଠିକି ପଠା ହେଇଛି। ତ ଆପଣ ମାନେ ଅପିଲ କରିବାକୁ ଚାହୁଁଛନ୍ତି ନା କାହାକୁ ଦେଇଛନ୍ତି ନା କଣ ଚାହୁଁଛନ୍ତି?
ଅପିଲ ପାଇଁ ଦିଆ ହେଇଛି ଜଣେ ଅଜୟ କୁମାର ମହାରଣା ଓକିଲ।
କେବେ ଦେଇଛନ୍ତି?
ହେଇଗଲା ନା ମାସେ ପରେ।
ହଁ, ସିଏ କିଛି ଅପିଲ ଫାଇଲ କରି କିଛି ନମ୍ବର ଆପଣଙ୍କୁ ଦେଇଛନ୍ତି?
ଆଜ୍ଞା ଦେଇଛନ୍ତି।
କେତେ ନମ୍ବର?
ନାଇଁ ସାର୍, ଏଟା ଖାଲି ଆମେ ନେଟରେ ସାର୍ ଚେକ୍ କରିଥିଲୁ, ସେଟା DSREF।
ନା ସେଟା ନୁହଁ।
ସେଇଟା ନୁହେଁ, ସେଇଟା ହଉଛି ସେଇଟା କୋର୍ଟ ତରଫରୁ ଆସେ। ସେଇଟା ଫାଶୀ ହେଇଗଲେ ଗୋଟେ ରେଫରେନ୍ସ ହେଇକିନା ଆସେ ଏଠିକି। ଆପଣଙ୍କର ହାଇକୋର୍ଟ ତାକୁ ବିଚାର କରିବ ଫାଶୀ ଆଦେଶ ରହିବ କି ନାହିଁ, କି ଆପଣଙ୍କର ଖଲାସ ହେବେ କି ନାହିଁ, ସେଇଟା ଗୋଟେ ଅଲଗା କେସ୍। ତା ଦେହରେ ତା ସାଙ୍ଗରେ କିଛି ସମ୍ପର୍କ ନାହିଁ। ତା ଦେହରେ ବି ଆମେ ଓକିଲଙ୍କୁ ନିଯୁକ୍ତି କରିବୁ, କିନ୍ତୁ ଆପଣଙ୍କ ତରଫରୁ ମଧ୍ୟ ଆପଣ ଚାହିଁଲେ ଏଇ ଯୋଉ ଦଣ୍ଡାଦେଶ ବିରୁଦ୍ଧରେ ଆପଣ ଅପିଲ କରିବେ। ଆପଣ ଗୋଟେ କାହାକୁ ଦେଇଛନ୍ତି ପରା କହୁଛନ୍ତି?
ଆଜ୍ଞା ଦେଇଛି, ଅଜୟ କୁମାର ମହାରଣା।
ଅଜୟ କୁମାର ମହାରଣା କୋଉଠିକା ଆଡଭୋକେଟ?
କଟକ ବୋଲି ମୁଁ ଜାଣିଛି।
କଟକର। ଆଉ ତାଙ୍କର କିଛି କଣ୍ଟାକ୍ଟ ନମ୍ବର ଆପଣଙ୍କ ପାଖରେ ଅଛି?
ଅଛି ସାର୍।
କେତେ ନମ୍ବର କୁହନ୍ତୁ?
ମୁଁ ତ ଆଣିନି ଖାତାରେ ଅଛି।
ଆଚ୍ଛା, ନମ୍ବରଟା ନେଇକିନା ଆସନ୍ତୁ ଯାଇକିନି, ଯଦି ଅଛି ଆପଣଙ୍କ ପାଖରେ। ହେଲା, ଆମେ କିଛି ସମୟ ପରେ ଆପଣ ଇଏ କରିବୁ, ତାଙ୍କଠୁ ବୁଝା ଯିବ ଯେ ସିଏ ଫାଇଲ କରିଛନ୍ତି। ଅଛି, ଦିଅନ୍ତୁ ଦଉନାହାନ୍ତି।
9937
37
34
00
80
82
80
80।
ଆଜ୍ଞା,
ଆଉଥରେ ପଢ।
9937
ହଁ
34 00 80
1 2 3 4 5 6 7 8 9 10 ଠିକ ଅଛି। କଣ୍ଟାକ୍ଟ କରନ୍ତୁ, ପଚାରନ୍ତୁ ଏ ଦି ଜଣଙ୍କର ଫାଇଲ କରିଛନ୍ତି ନା ନାହିଁ। ହେଲା, ଯଦି କଣ୍ଟାକ୍ଟ ଟିକେ ପରେ ଆପଣଙ୍କୁ ଇଏ କରିବେ, ଆପଣ ସେଠି ଥାଆନ୍ତୁ ସେଠି। ହେଲା, ଆପଣ ଓକିଲ ଫାଇଲ କରିଛନ୍ତି ନା ନାହିଁ ବୁଝା ଯାଉ, ତାପରେ ବନ୍ଦୋବସ୍ତ କରାଯିବ। ହେଲା। नंबरटा टिपिक नेले तो ठीक से ठीक है हाँ डाकुन अच्छी रेडी अछि तो किए अछंती अब 17 रे किए अछंती कि आइटम नंबर 17 अनुराग महापात्र दीटा अपील अछि ना आइटम हाँ प्रीवियस ऑर्डर हाँ कौन कौन है देखिए प्रीवियस ऑर्डर it is made clear that no further adjournment है let the purpose of paper भी receive करना है no from other council भी engage सर को दे देवे दी डायरेक्टर है सर एंगेज कर दे 70 नंबर 18 नंबर और एग्जाम का पेपर बुक किया है जो आसीओ गोटे कोई छाड़ देगी तापर इतर आसीओ तापर टा रखो सीरियल टकी जानते अच्छे नोड़ा सब स्ट्रीमलाइन कर दे
Item 19. Item 20.
item 19 और ऑर्डर बाकी it is the song when guess कर दो next
Item 20.
Item 20, my lord, I am appellant. I am for the appellant.
Argudi matter. What is your good name?
Purno Chandra Behera. No.
Please use the mic. Come here. Mic adjust करो.
Passed by the additional session judge.
Just a minute. P02 रे life imprisonment age. Wasum the FIR person. Yes, Mr. Naik, what happened?
आज अपील फाइल कर এবং 14/11 ডেথ রেফারেন্সেস মানে পাওয়ার ফাইল করছেন কথা হেলে দাম
आज अपील फाइल करछन
କହିଲି ନମ୍ବର ଦବା ପାଇଁ ବି କହିଛି ତାଙ୍କୁ ଫାଇଲ ନମ୍ବର ହେଲେ ଦେବେ 14/11 ରୁ ଡେଥ୍ ରେଫରେନ୍ସ ରେ ପାୱାର ଫାଇଲ କରିଛନ୍ତି
ତାଙ୍କ ନାଁ ହେଉଛି ଅଜୟ କୁମାର ମହାରଣା ତାଙ୍କୁ ଡାକିକି କନେକ୍ସନ କରୁଛୁ ଏଇଟା ବଡ କର କେତେ ତ ହେଟା ସେଟା ବାହାର କର 16 ନମ୍ବରଟା ବାହାର 16 ହଁ ନାଇଁ ନା ଦିଟା ବାହାର କର हाँ प्रकाश बेहरा और नंदकिशोर सेठी तो आपण जो नंबर टी देले वकिलंकर अजय कुमार महाराणांकर तांकू सरकारी वकिल जोगाजोग कले आउ सी कहले जे आज सी आपणकर अपील फाइल करूछंती हला आउ द्वितीय कथा से जो डेथ रेफरेंस केस टी उठीची विचार पाई ता देर मध्य से वकिलतनामा दाखल करछंती 14 तारिख रे तेणु से आमे कहीथिलु हाजर कि ये करिया पाई तो मैटरटा जेतेबेले फाइल हबो ଏବଂ ଆପଣଙ୍କୁ ପୁଣି ଶୁଣାଣି କରିବାକୁ ଆପଣ ଦେଖିବେ ସବୁ କେମିତି ଶୁଣାଣି ହଉଛି ସେ ବିଷୟରେ ଆପଣଙ୍କୁ ଜଣାଇଯିବ ଠିକ ସମୟ ହେଲା।
एपिल फाइल कला परे ता नंबर आसला परे या सहित ताकू जोड़ी के
जोड़ी
तापरे केस आरंभ हो सुनानी आरंभ
ऑन এটা এটা ওভারঅল অর্ডার মানে এমসি অর্ডার হয়েছিল না খালি আচ্ছা ଖାଲି କିଛି ଅର୍ଡର ତ ପାସ୍ ହେଇନି
ଆଡମିଟ ହେଇନଥିଲା ହେଇନି ଏଇଟା।
When the matter was called yesterday, no one appeared. Therefore, we asked the London State Council to ensure the appearance of the two condemned prisoners, namely Prakash Behra and Nandkishore Sethi, to virtual mode from the concerned jail. Both the condemned prisoners have appeared through virtual mode, and they stated that they have already handed over the case to one Ajay Kumar Maharana for filing the criminal appeal and also to appear in the DSREF 4 of 2024. The mobile number of the said advocate was supplied, and accordingly, the London Council for the State contacted Mr. Ajay Kumar Maharana, who stated that he will file the criminal appeal during course of the day, and he has already filed his wakalatnama in DSREF number 4 of 2024 on 14th of November 2024. Stop. Let the registry place the dhinama on record, and if any criminal appeal is filed, the same should be tagged to this DSREF 4 of 2024 and be placed for admission. ହେଲା ତ ସେଇଟା ଫାଇଲ କଲେ ଆପଣ ଓକିଲ ବାବୁ ଦିଟା ଯାକ ଯୋଡି ହେଇକିନା ଆସିବ ହେଲା ଆଉ ଓକିଲ ବାବୁ କହିଛନ୍ତି ଯେ ନମ୍ବର ଜଣେଇବେ ବୋଲି ଠିକ ଅଛି।
Item 20.
My lord, page 22 is the FIR.
22 is the FIR.
My lord.
ଆଚ୍ଛା ପଢନ୍ତୁ।
ମହାଶୟ ଲେଖି ଜଣାଇବାର କାରଣ ଏହିକି ଯେ ମୁଁ ଶ୍ରୀ କଳାସିନୀ ବେହେରା ବୟସ ପ୍ରାୟ 45
କଳସିନୀ ବେହେରା କେତେ ନମ୍ବର ସାକ୍ଷୀ?
accused no, she is the informant.
हाँ
ସାକ୍ଷୀ ନମ୍ବର କେତେ?
ସାକ୍ଷୀ PW1
ହଉ ପଢନ୍ତୁ।
ସ୍ୱାମୀ ବିଦ୍ୟାଧର ବେହେରା ସା 716 ଥାନା ବିଶୋଇ ଜିଲ୍ଲା ମୟୂରଭଞ୍ଜ ଗତକାଲି ତା 1/3/2007 ତାରିଖ ରାତି ସମୟ ପ୍ରାୟ 12:30 ମୁଁ ଶୋଇଥିବା ଅବସ୍ଥାରେ କବାଟ ଖୋଲିବାର ଶବ୍ଦ ଶୁଣି ଉଠି ଦେଖିଲି ଯେ ମୋର ଜ୍ୱାଇଁ ଶାବଳ ଧରି ଛିଡ଼ା ହୋଇଅଛି। ସଙ୍ଗେ ସଙ୍ଗେ ମୋ ସ୍ୱାମୀକୁ ଡାକିବାରୁ ମୋ ଜ୍ୱାଇଁ ପଶୁପତି ବେହେରା ଶାବଳଟିକୁ ଅଗଣାରେ ପକାଇ ଦୌଡ଼ି ପଳାଇଲା। ମୋ ସ୍ୱାମୀ ମଧ୍ୟ ସେ ପଳାଇବାର ଦେଖିପାରିଛନ୍ତି। ଏହି ଅସ୍ୱାଭାବିକ ଆଚରଣ ଦେଖି ମୁଁ ପାଟି କଲି ଓ ମୋର ସ୍ୱାମୀ ମଧ୍ୟ ପାଟି କଲେ। ସନ୍ଦେହ ହେବାରୁ ଘରେ ପଶି ଆମେ ଦେଖିଲୁ ଯେ ଆମର ବଡ଼ ପୁଅ ଅଞ୍ଜନ ବେହେରା ବୟସ ପ୍ରାୟ 23 ବର୍ଷ, ସାନ ପୁଅ ନିରଞ୍ଜନ ବେହେରା ବୟସ ପ୍ରାୟ 21 ବର୍ଷ ରକ୍ତାକ୍ତ ମୁମୂର୍ଷ ଅବସ୍ଥାରେ ପଡ଼ି ଅଛନ୍ତି ଓ ମୋର ସମ୍ପର୍କୀୟ ପୁତୁରା ଝାଫଲ ବେହେରା ବୟସ ପ୍ରାୟ 21 ବର୍ଷ ଘର ଭିତରେ ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ମରି ପଡ଼ିଛି। ମୋର ଓ ମୋ ସ୍ୱାମୀଙ୍କର ପାଟି ପୁରି ଶୁଣି ଆମ ଘର ପାଖର ଲୋକମାନେ ରଙ୍ଗା ବେହେରା, ଚୁନୁକ ସିଂ, ଡୁନା ବେହେରା, ପ୍ରଭା ବେହେରା ଓ ଅନ୍ୟମାନେ ଘଟଣାସ୍ଥଳକୁ ଆସିଲେ ଓ ଏ ବିଭତ୍ସ ଦୃଶ୍ୟ ଦେଖି ସମସ୍ତେ ଆଶ୍ଚର୍ଯ୍ୟଚକିତ ହୋଇଗଲେ। ମୋର ଦୁଇ ପୁଅ ବଞ୍ଚିଥିବା ଆଶା ନେଇ ଲୁହାକାନିରେ ଶେଖ ସଫି ବାବୁଙ୍କର
शेख सफी बाबूंकर
ବାଡ଼ିରେ ଗାଡିରେ
ମାର୍ଶାଲ
ଗାଡିରେ ମୋର ଦୁଇ ପୁଅଙ୍କୁ ନେଇ ମୋର ଦିଅର ଇନ୍ଦ୍ରଜିତ ବେହେରା ଓ ଅନ୍ୟମାନେ ବିଷୋଇ ଡାକ୍ତରଖାନାକୁ ଆଣିଥିଲେ। ମାତ୍ର ଡାକ୍ତର ତାଙ୍କୁ ମୃତ୍ୟୁ ଘୋଷଣା କରିବାରୁ ସେମାନେ ମୋର ଦୁଇ ପୁଅକୁ ଘରକୁ ଫେରାଇ ଆଣିଲେ। ପଶୁପତି ବେହେରା ପିତା ନଗେନ୍ଦ୍ର ବେହେରା ସତରାଛିଡା ଥାନା ଘୋଡାବଳା ଜିଲ୍ଲା ପୂର୍ବ ସିଂଭୂମ ଝାରଖଣ୍ଡ। ମୋର ଏକମାତ୍ର ଝିଅ ପୁଷ୍ପଲତାକୁ ଆଜକୁ ପ୍ରାୟ 2.5 ବର୍ଷ ହେବ ବିବାହ ହୋଇଅଛି ଏବଂ ସେମାନଙ୍କର ଗୋଟିଏ 1.5 ବର୍ଷର ପୁଅ ଅଛି। ଗତ 19/2/2007 ତାରିଖ ମୋର ବଡ ଭାଇ ବଂଶୀଧର ବେହେରାଙ୍କ ବାହାଘରକୁ ମୋର ଜ୍ୱାଇଁ ପଶୁପତିର ସାନ ଭାଇ ସୁକୁରୁଣା ବେହେରା ସାତସଳରୁ ଆସିଥିଲା ଏବଂ ତା 21/2/2007 ତାରିଖରେ ସେ ତା ଗାଁ ସରଙ୍ଗଛିଡାକୁ ଫେରିଗଲା। ସେ ସାତସଳ ଗାଁରେ ରହିବା ଭିତରେ ମୋର ଝିଅ ହୋଇଥିବାରୁ ପଶୁପତି ବେହେରା ସମ୍ପତ୍ତି ଭାଗ ପାଇବା ନେଇ ଏଠି ସେଠି କହି ବୁଲୁଥିଲା। ମୋର ଜ୍ୱାଇଁ ମଧ୍ୟ ଅନେକ ସମୟରେ ଏହି ସମ୍ବନ୍ଧରେ ଭାଗ ପାଇବା ନେଇ ମୋ ଝିଅକୁ ନାନା ପ୍ରକାର ଅତ୍ୟାଚାର ପିଟା ମରା କରେ। ଏଣୁ ମୋର ଦୃଢ ସନ୍ଦେହ ଯେ ସୁରୁକୁମା ବେହେରା ମୋ ଜ୍ୱାଇଁ ମୁଣ୍ଡରେ ସମ୍ପତ୍ତି ଭାଗ ପାଇବାକୁ ନେଇ କୁମନ୍ତ୍ରଣ ଦେବାରୁ ମୋ ଜ୍ୱାଇଁ ପଶୁପତି ବେହେରା ଏଭଳି ଜଘନ୍ୟ କାଣ୍ଡ କରି 3 ଗୋଟି ନିଃସ୍ୱାର୍ଥ ଜୀବନ ହାନି କରିଛି।
ନାଇଁ 2 ଜଣ ତ ମଲେ, ଇଏ ବି
ତିନି
ମରିଗଲେ?
ତିନି ଜଣ।
ଜଣ
ମାନେ ଏଇ ଯୋଉ ଝାପଲ ବେହେରା ବି ପରେ ମରିଗଲା?
ଆଜ୍ଞା।
କାରଣ ଡାକ୍ତରଖାନାକୁ ସିଏ ଦୁଇ ପୁଅକୁ ନେଇଛି ବୋଲି କହିଲା। ଦୁଇ ପୁଅ ମାନେ ଅଞ୍ଜନ ବେହେରା ଆଉ ନିରଞ୍ଜନ
ବେହେରା।
କିନ୍ତୁ ଇଏ ସମ୍ପର୍କୀୟ ଝାପଲ ବେହେରା ଆଚ୍ଛା ସିଏ ମରିଯାଇଥିଲା। So it appears from the judgment that 2 persons face trial.
2%
One is that Pasupati Bera, the other is
Surukuna Bera, the brother of the appellant.
Brother of the said appellant. And
both are sons of Nagin.
302/34 and 120B. And that Surukuna Behra was acquitted. This man has been
convicted,
found guilty under 302. Case based on circumstantial evidence.
Eyewitnesses
Actual
circumstance.
Who is the eyewitness?
PW9 is the eyewitness.
PW9?
9 is the wife of the
deceased.
The appellant.
Appellant?
My lord.
Wife of the appellant?
My lord.
Oh.
Accused
Page 53 is my husband.
Page 53, PW9.
The other accused.
The PW9 को पढ़े तो.
Page 53. PW9 Bandita alias
PW9
PW9 page 53. Accused Pasupati is my husband. The other accused is the brother of the Pasupati. Informant is my mother. Deceased Anjana and Niranjana were my younger brothers. The other deceased Jhapal was my relative. Occurrence took place about 2 years and 8 months back. Myself and my husband Pasupati were staying in our father's house since 2 years prior to the occurrence. Myself, my husband, and our child were sleeping in one room of the house of my father. On the night of the occurrence, Anjana, Niranjana, and Jhapal were sleeping in the next room connected by a door. At about midnight, to 1 a.m., I heard some sound. I got up and found that my husband Pashupati was inflicting blow by a hammer on Anjana, Niranjana, and Japal. When I saw the accused, he rushed towards me with wide eyes, holding the hammer. Out of the fear, I again lied down, sleep on the bed. Anjana, Niranjana, and Japal were lying in the bleeding condition. When I again got up, I found Pasupati was not there. Accused, accused Pasupati committed such offense on the ill advice of the accused Surukana with a hope to get the property of my father. Cross-examination. Accused Pasupati is my second husband. I was married earlier to another person. My father and mother came to the spot of occurrence after about 10 to 15 minutes of the occurrence. To that time, many villagers also gathered there. I have seen my father and other villagers at that time, but at that time I had not talked to them. I told about the occurrence to my parents after 3 to 4 days. Police arrested accused Pasupati on the next day of the occurrence. I disclosed the matter to the villagers. After telling the same to my parents, the police came to our house. I was examined by the police about 8 to 10 days of the occurrence. No other person was examined by the presence. I have not seen when my husband went away after the occurrence. There was an electric light in our house. The room in which I was sleeping and the room in which Anjan, Niranjan and Japal were sleeping. Electricity. I have not gone out immediately after the occurrence. It is not a fact that it is not possible to see the occurrence in the room where my brothers were sleeping, remaining in my room, as both of the rooms are divided by wall. The witness volunteers that there is a door in between the two rooms. Prior to the occurrence, accused Pasupati had no dispute with anyone of our family. I have not marked any revengeful attitude with the accused Pasupati prior to the occurrence. It is not a fact that accused Pasupati was being treated at Ranchi due to unsoundness of mind. It is not a fact that I have not seen the occurrence, and in order to get a conviction, I developed the story. Accused Pasupati.
This is on behalf by Surukuna.
The accused Pasupati in the dock is my husband. He had 6 brothers. I went to the house of Pasupati and stayed there for 6 months. His parents are alive. To that time, only 2 brothers were married. Other brothers of the Pasupati were not married to the time of my marriage. Surokana is an inhabitant of Jharkhand state. The marriage of my cousin brother was performed 8 days prior to the occurrence. It is not a fact that village Satsolo and village Luhakani are a distance of 2 kilometers. Both the villages situated on either side of the road. Police has examined me about the occurrence for 2 to 3 times. My statement was reduced to writing for the first time, and on later on my statement was not writing. It is not a fact accused Surukana had not given any ill advice to Pasupati and that I am deposing falsehood.
Who is the doctor who conducted PM?
PW 13, 14 and 15. That is page number 62.
62 or 42?
Dr. Pratap Kumar
Dr. Pratap Kumar Mahapatra. 41.
On 2/3/2007, I was serving at SDS hospital in my present post. On that day, on police requisition, conducted the PM examination of Niranjana Behera, son of Bimbadhara Behera of village Satsolo, and found as follows. Rigor mortis present in all 4 limbs. Face was total disfigured. Presence of multiple bleeding injuries over face, such as lacerated wound over mid and lower part of the forehead of size 2 inch into 3 by 4 inch, and brain deep with crossed fracture of underlying frontal bone. Lacerated wound at outer Contours of left eye of size 2 inch into 3 by 4 inch of and brain deep with fracture of underlying bone. Fracture crosses wound over lower part of nose and upper limb disfiguring the nose with fracture of underlying maxilla and distorting of normal dentition. Both eyeballs found ruptures irregularly and collapsed. Oozing of jelly fluid and liquid blood of, of pressure. There was also oozing of liquid blood with liquid brain matter from injury number 1 and 2 on pressuring
On pressure.
on pressure. The injuries are antemortem in nature and might have been caused by the heavy thrust by hard and blunt open object. On, on decision portion of the brain below injury number 1 and 2, that is frontal lobe, is totally smashed and mixed with clotted blood. There is a multiple fracture of skull bone, mainly frontal, maxilla, and nasal bone, which were irregularly broken into pieces. Other internal organs were found intact, but pale stomach
But pale.
pale stomach contains semi-digested food materials. Death was due to injury to vital organ, that is brain, hemorrhage, and shock. Time since death might have occurred 12 to 18 hours prior to PM examination being conducted at 4 p.m. on 2/3/2007.
Okay. Next,
Next,
Table 14.
my lord. On 2/3/2007, I was an assistant surgeon of SDS Rairangpur. On that day, on police requisition, I conducted PM over the dead body dead body of Anjan Behera, son of Bimbadara Behera of village Satsol, and noted the following. An average body fluid of the male body of aged about 23 years with rigor mortis present in all the four limbs, eyes closed, mouth closed. There was a bleeding from nose injuries. 1. Bleeding lacerated wound of 4 cm into 1 cm into skin dipped on the right side of her head. 2. Bleeding lacerated wound of 4 cm into 1 cm and skin depth in peripheral region, right side. There was a depression area extending from right parietal region to right zygomatic process and mid forehead foretite ear. On decision, dinner was fracture of right parietal bone, right side of frontal bone, right orbital fossa, and right zygomatic process with injury to the brain matter deep to the fractured skull bone. Chest wall was intact, heart was intact, both the chambers were empty of blood, both the lungs were intact and pale. Slim liver and both the kidneys were intact and pale. Stomach was intact and contained semi-digested food. All the injuries were antemortem in nature. Death was due to head injury and hemorrhage shocks. Time since death was within 24 hours at the time of my examination being conducted at 4:20 p.m. on 2/3/2007.
Next,
Next, madam, 15. On 2/3/2007, I was ONG specialist at SDS Rairangpur. On that day, on police requisition, I conducted PM examination on the dead body of Jhappal Bera, son of Manikhanda Bera of Odanga Santra, PS Badrasola district, Singhbhum, Jharkhand, and found as follows. A young male of 21 years with thin body, built eyes closed, cornea hazy pupils, dilated mouth closed, rigor mortis present in all the four limbs. On local examination, I found lacerated wound on the left side of the forehead, 2 inch above the left superciliary artery of size of 1.12 inches into 5 inches. Skin deep with depressed fracture of underlying frontal bone. The upper margin of the wound and the fracture is semicircular. On the description, displaced fracture of the left half frontal bone of the size 2.1 in 2 inch into 1 bone deep with laceration of the underlying frontal lobe of brain and associated with intracranial hemorrhage and
Intracranial.
hemorrhage and hematoma.
Brain and
Meninges congested.
Cause of the death was due to coma as a result of injury to vital organ like brain due to the head injury. All the injuries were antenatal in nature. Time since date within 24 hours prior to the holding PM examination being conducted at 4 p.m. on 2/3/2007. Who is the IO? IO is the PW 17 and 16.
16, 17.
16, 17. 17 is what? IO.
PW 16 को दिया was the IIC.
IIC is registered by
case registered कला investigation कला.
Again.
With
17 is SDP.
visited the spot कला.
On 2/3/2000.
तो सही दिनों handover कर दीजिए investigator. To Sridhar Mahanta, अच्छा, Circle Inspector.
On 2/3/2007, I was IIC Bisho EPS. On the same day at 7 a.m. on the report of complainant Srimati Kalasini Behera, I registered the Bisho EPS case number 18 of dated 2/3/2007 under section 302 IPC and took up the investigation. Exhibit 5 is the report and Exhibit 5.2 is my endorsement with this signature. During course of inspection, I examined the complainant and other witness, visited the spot and prepared the spot map. Exhibit 13 is the spot map and Exhibit 13/1 is my signature. I seized one crowbar in presence of the witness and prepared the seizure list. Exhibit 4 and Exhibit 4/2 is my signature. I conducted inquest report about the dead bodies of the Jhapal Behera, Niranjan Behera and Anjan Behera. Exhibit 1 is the inquest report regarding Jhapal. Exhibit 1/2 is my signature. Exhibit 2 is the inquest report of this is Niranjana. Exhibit 2/2 is my signature. Exhibit 3 is the inquest report of this is Anjana Behera. And Exhibit 3/2 is my signature. I dispatched the dead body to SDS Rairangpur for PM examination, seized the sample earth, blood stain, earth from the spot, and prepared the seizure list by Exhibit 8. And Exhibit 8/2 is my signature. I arrested accused Pasupati Behera and seized the wearing apparels of the accused Pasupati Behera. Exhibit 14 is the seizure list and 14/1 is my signature. I also seized the wearing apparels of the deceased person and sample blood of the Pasupati and nail clipping of the accused Pasupati and prepared the seizure list. Mark Exhibit 15 and Exhibit 51 is my signature. On 2/3/2007, I handed over the investigation of this case to Sridhara Mahanta, CI Rairangpur MO3 is the crowbar.
2-3 means on the very day.
It is not a fact that without prior investigation, accused Surukuna has been implicated. Spot is the middle room of the house of the informant. There are 5 rooms in the house of the informant in ill condition. On the north side, there were 2 rooms which were faced to the south. Other rooms faced towards west. There were common wall of the rooms with interconnected doors. I have not mentioned in the spot map that the rooms were connected internally by doors. It is a fact that Kalasini, the informant, had not stated before me that she heard a sound like thud thud. It is a fact that Kalasini, the informant, had not stated before me that accused Pasupati was staying in her house since 1 year of the date of occurrence. It is a fact that witness Bimbadhara Behera had not stated before me.
Right. So the evidence of apart from the eyewitness evidence that PW9, is there any other eyewitness?
No.
No. So one is the eyewitness PW9. 3 doctors are there. So you assaulted by means of a hammer, and your wife has stated like that, and it is corroborated by the medical evidence. And as it appears from the evidence of PW 17, at your instance, that hammer was also recovered. That is, the seizure list is there. Exhibit 7 is the seizure list. And the doctor who has conducted the postmortem examination, he has also, that hammer was sent to him as it appears, and he has reported that this injury can be possible by such hammer. So the hammer was also sent, as it appears, for the chemical examination, and C report is at flag page 84, and it indicates that there was human blood in that hammer. It is marked as serial number 8, and so how do you get over this evidence, or what are the other evidence available on that book? Anybody has stated, the eyewitness has stated, and corroborated by the family members that you have seen at that place.
PW1
PW1.
one is informant and
अच्छा,
PW2
one कौन देखी थी पढ़ देले PW1.
I know both the accused person. Accused Pasupati is my son-in-law.
Son-in-law.
Accused Surkuna is the brother of the accused Pasupati.
Father-in-law.
This is Niranjana and Anjana are my son. This is Zapal is my relative nephew. The occurrence took place in my house about 2 years, 5 months back at about 12:30 a.m. in the night. Myself and my husband were sleeping in one room. In another room, my two sons, Anjan, Niranjan and nephew Zapal were sleeping. Accused Pasupati and his wife were sleeping in another room, the entrance of which opened to the room in which Anjana, Niranjana, and Japal were sleeping. At about midnight, I heard some sound. I woke up and awakened my husband, Bimbadhara Behera. When we came out, we found Pasupati was standing holding a crowbar. When, he, when we called him, he ran away throwing the crowbar. Unsuspicious, myself and my husband entered into the room where my two sons and nephew were sleeping. I found that my two sons, Anjana and Niranjana, and nephew Japar, were in serious condition, having was bleeding. At that time, my nephew Japal was lying dead. We shouted. Our neighbors reached at the spot, hearing our out shouting. With the hope that my two sons might survive, the neighbors took Anjana and Niranjana to Viswai Hospital, but the doctor found them dead. Hence, the dead bodies of Anjana and Niranjana were brought back to my house. Hence, myself and Sastri Mandal went to the Viswai PS. On the next morning, Sastri Mandal scribed the affair as per my version, read over and explained the same to me, and thereafter I affixed my thumb impression. Thereafter, police came to our house. About 1 year prior to the occurrence, Pasupati was staying in our house. During his stay, Pasupati was insisting his wife to persuaded my husband to get the property in his name. Accused Surkuna also was persuading Pasupati to get the properties of my husband in his name. Pasupati has killed my two sons, Anjana and Niranjana, and nephew Japal. Cross exam. Bansidhara Behera is the elder brother of my husband, and we are living in one house. We are occupying 5 rooms, and Bansidhara and his family were occupying 3 rooms. Our rooms were situated in east-west direction. In the first room, myself and my husband were staying. In the next room, my son and nephew were sleeping. And in the next room, Pasupati was staying with his wife. 2 other rooms were vacant. The entrance of all the room faced toward north. There was a common wall of the room. On the other side of the room, Bansidhara and his 3 rooms. The courtyard of Bansidhara and our are separate, divided by wall. My daughter married Pasupati about 4 years back. After the marriage, my daughter stayed with her husband in the house of each husband for about 1 year. It is not a fact that Pasupati was not sound mentally. It is not a fact that he was being treated for that purpose at Ranchi by me and my husband. I have heard some sound like
Dhad dhad.
about midnight. It is not a fact that I have not stated to the IO that I heard the sound like that. It is not a fact that I have not stated to the IO that Pasupati was staying in our house for about 1 year. It is not a fact that Pasupati has not murdered my two sons and nephew, and I am deposing the falsehood. Accused Surkuna and his family members stay in the state of Jharkhand. It is not a fact that I have falsely implicated the accused Surkana.
Okay, so that is one witness who has seen you that you were standing there holding a crowbar, and then threw the crowbar and ran away. Then similar statement, of course,
PW2.
PW2. Who is the father-in-law?
Father.
Similar statement. Yes, when I called him, he told that he was going to run away. Okay. So there was an attempt by the London Council for the defense to take a plea of unsoundness of mind. But that suggestion which has been given to these two witnesses, including the wife, they have said no, right? And perhaps the defense has also examined one witness who is the brother of the appellant.
76.
And he has also stated, but सुकुरण बेरा सुकुरण बेरा किए
That was accused.
अच्छा वो accused को से कले ता भाई से ताकू एग्जामिन कले सेही पॉइंट रे किंतु से कहिला जे मु कोनोसी डॉक्यूमेंट आनी प्रोड्यूस करी परिबी ना
At that time she is a cost.
बाकी अन्य विटनेस गुडा कोन PW3 कोन कहूची
ANI is a seizure. PW4 is your seizure. PW3, I know the accused person. Page 40.
He immediately on hearing this out, he reached there and found Niranjan
found this
in a pool of blood, and they were severely injured on their head. They were lying inside the house of
Same statement is of course also PW4 is a witness to the inquest, and all other witnesses have stated that the three deceased persons were lying there and they were shifted to the hospital. Two of them were shifted. One was dead by then. That is
Jhapal. Niranjan and other one. Anjan, Niranjan were taken.
Of course, they have not seen the appellant. They came afterwards.
They are just post-occurrence witnesses.
PW8 होची से जो ये रो
Subscriber of the FIR.
हाँ से scribe of the FIR ता छड़ा से जो येटा recover हला hammerଟା अच्छा से पूरा गोटे कोन हो एटा पकई दी जाइतला स्पॉट रे कोन कहउजंदी स्क्रू बारटा आ गोटे hammerटा रिको
दिटा कहिची
hammer रू किंतु मिलिची रक्त
हां सेटा
जहां हाँ
पकई दितला लीड
Police recorded the statement read over Swanshu. तापर से कहउचंती जे police was led by accused Pasupati to the well where the hammer was hidden and at the instance of Pasupati that was recovered from the well. Seizure list is exhibit 7. And your plea in the accused statement is total denial.
Total denial.
Denial. So what is your submission, Learning Council? How do you get over this evidence of this eyewitness which is also to some extent corroborated by the 1 and 2. They have seen you near that spot at the time of occurrence. Then the dead body was found there. One dead body and two were shifted, and all the doctors who have examined the dead bodies conducted post-mortem. They have also noticed injuries, and injuries were possible by that hammer, and that also contains human blood. It was recovered at your instance, and you have taken a plea of insanity, but no medical document has been proved. Some suggestion, of course, has been given to your wife, PW9, and your in-laws, parents-in-laws, and they have denied it. So, and they have stated the motive behind the commission of crime, that is that property dispute kara. Property dispute. Huh? Property dispute. Property dispute. FIR रे तो बोधे से विषय अछि FIR रे कोड वाला कोड उठे लाइन तो अछि लास्ट लाइन लास्ट 3 हाँ इट पर लिखा है से आसीथिला तापरे 19 तारिख रे दिन मोर बड़ भाईर बंशीधर बेहरार बाहागर को ज्वाई आसथिले सान भाई सुरकणा बेरा 7 तोलको आसीथिला 21 तारिख दिन से तार गाँ सरग छिड़ा को फेरीगला ओके से 7 तोल गाँ रे रहिवा भितरे मोर सुआंशो गोटिए झियो होइथिबारु पशुपति बेरा संपत्ति भाग नहीं एठी सेठी कही बुलुथिला मोर झियो को नाना नहीं मोर जुआई अनेक समय यही संपत्ति भाग पाइबा नहीं मोर झियो को नाना प्रकार अत्याचार और पिटा मरा करे एणु मु दृढ़ संदेह जे मोर जुआई मुंडरे संपत्ति भाग पाइबा कुमंत्रणा देइथिबारु सुआंशो हला से भली जघन्य कांड करी तीनोटी जीवन नहीं so this FIR statement is there and in court also in paragraph number 4 of PW 1 page 35 read it out that about 1 year prior to the occurrence, Pasupati was staying in our house. During his stay, Pasupati was insisting his wife to PW9 PW9 to persuade my husband to get the properties in his name. Accused Surkana also was persuaded to get the properties of my husband in his name. Pasupati has killed my 2 sons. Okay, now you same thing has been stated by PW2, the father-in-law, paragraph number 3. Read it out, page number 38. Accused Pasupati was staying in my house for about 1 year since the date of occurrence. Pasupati was demanding and was telling my daughter so that he will get all the property of mine. Accused Surukuna came to the marriage ceremony of my son of my elder brother, where he was persuading Pasupati to grab my property.
Accused Pasupati had killed my two sons and my nephew to grab my property.
And
This witness has stated that I found that accused Pasupati was running away throwing the crowbar. When I called him, he told that he was going outside and ran away.
And there was no reason on the part of your wife to depose falsehood against you. Why she would depose falsehood?
Father-in-law,
Father-in-law, mother-in-law, to some extent,
Yes.
and PW 9 also, and evidence, medical evidence corroborates the evidence of the PW 9. Two were sons. Who is the third one who was killed?
Nephew.
Japal.
Japal na
He was nephew.
ସେଟା କିଏ କହିଛି? Deceased as my related nephew. So anything to submit on this? This is this evidence. No, I got that. No blood stain found in the wearing apparel of the accused. Wearing apparel of the appellant was seized. Seized. And it was sent for C examination. And the C examination report indicates एगुड़ा जो इटी कहाँ ब्लड गुड़ा ये जो पेज 84 रे 82 पेज 82 serial number 9 just 82 रे हाँ one blue color गंजी no blood नहीं आपण इटा पूर्वରୁ ଦେଖିବେ ଆପଣଙ୍କର ଏଟା पेज accused ଆପଣ accused जो କହୁଛନ୍ତି ନା पेज 8 पेज 80 serial number 9 ହଁ 9 ଟା ହଉଛି ଆପଣଙ୍କର blue color half ଗଞ୍ଜି ହଁ and 10 ହେଲା ମାର୍କ ହେଇଛି exhibit କେତେ I ଗୋଟେ I ତାପରେ ଆପଣଙ୍କର ଯେଟା ନାଇଁ ସେଟା ନାହିଁ ଯେଟା ହଉଛି accused body କେମିତି ଜାଣିଲେ one red color stripe lungi of the accused ତାପରେ bottle so ଦିଟା ଦେଇଥିଲେ ଆଉ 12 ଟା ହେଲା nail clipping ତ I ଯେ ରେ ଆପଣ କିନ୍ତୁ କିଛି blood ଆସିଲାନି ନା 9 and 10 just let us see and 11 I and J. No blood, no blood. Okay. ଏତିକି ହଉଛି ଆପଣ submission. ଗଞ୍ଜି ଆଉ ଗୋଟେ ହଉଛି ଲୁଙ୍ଗି 72. You were arrested by PW 16. The same day. Next. Same day. नहीं अपन arrested the Pasupati Behra, seized the wearing apparels. No, anybody has stated your that wife has he has not stated that this very lungi or ganji was wearing the deceased was the appellant was wearing at the time of occurrence. ताले ते लुंगी चेंज कर दी थी बता ये चेंज कर दियो तो जोटा अरेस्ट बेले जबत हैला सेई गोटा को ये पिंधी थिला बेली तो किसी एविडेंस नहीं आपण जदि चीफ रे समाने न आनिले आपण तो किसी आनी नांती जे ए लुंगी गुडा को पिंधी थिला आपण एटा जदि फेवर रे सी रिपोर्ट थिला ताहले कन्फ्रंट कर दी पारथांते किछि नाही जे कौन पिंधी थिला कौन कहि परिबो कि कौन एमसेंत किछि प्रश्न पचार नांती बोधे PW 9 तापरे लाइट अछि इलेक्ट्रिक लाइट से कहउचंती अछि जो रूम रे माने थिले ए जो तीन जन जाक थिले स्लीपिंग लाइटेड बाय इलेक्ट्रिसिटी आउ ये तार सेठी सोई थिला जे ତା ଆଡକୁ ମାନେ ତାକୁ ଆଖି ଦେଖେଇଲା ବୋଲି ସେ କହୁଛି ୱାଇଡ୍ ଆଇଜ୍ ହୋଲ୍ଡିଂ ଦି ହ୍ୟାମର, ତେଣୁ ଆଉଟ୍ ଅଫ୍ ଫିୟର ଆଉ ସେ ପାଟି ଫାଟି କଲାନି, ଚୁପକିନି ପୁଣି ଇଏ ହେଇଗଲା। ତାପରେ ଗଲା ପରେ ସେ ଯାହା ଦେଖିଛି one thing is there that this lady's name does not find place in the FIR as an eyewitness to the occurrence. Is it there in the FIR? And whether he was examined after so many days, as you said, let us see that 161 statement. PW9. Vandita Behrar statement that you are.
In cross examination, paragraph 6. Cross examination, page 54, paragraph 6.
No, ଘଟଣା କେବେ ହେଲା କି?
ଘଟଣା ହେଲା 1/3/2007
ନାଇଁ ନାଇଁ 2 ତାରିଖରେ FIR ହେଇଛି, ଏଭିଡେନ୍ସ ତାର ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି 2/3 ରେ।
ଠିକ ତ ଅଛି।
ହଁ ସେ ତ ଠିକ ଅଛି। କଣ ତାର ଷ୍ଟେଟମେଣ୍ଟରେ କହିଲା, ମୁଁ ଆପଣଙ୍କ ନିକଟରେ ହାଜର ହୋଇ ମୌଖିକ ଦେଉଛି କି 2.5 ବର୍ଷ ହେଲା ମୁଁ ପଶୁପତି ବେହେରାଙ୍କୁ ବାହାଘର ବାହା ହୋଇଥିଲି। ଆଚ୍ଛା, ବାହାଘର 6 ମାସ ପର୍ଯ୍ୟନ୍ତ ମୁଁ ସୁଆଣ୍ଡସୋ ଗାଁରେ ତା ସହିତ ରହିଲି। ମୋର ଗୋଟେ 1.5 ବର୍ଷର ପୁଅ ଅଛି। ଏହାପରେ ମୋର ବାପାଙ୍କର କହିବା ଅନୁଯାୟୀ ସୁଆଣ୍ଡସୋର ମୋ ବାପାଙ୍କ ଘରେ ରହିଲି। ମୋର କକାଙ୍କ ପୁଅ ବେଳେ ମୋର ସ୍ୱାମୀଙ୍କୁ ଆସି ତାଙ୍କୁ ଏକୁଟିଆ ଆମ ଘର ବିରୁଦ୍ଧରେ କୁମନ୍ତ୍ରଣା, ସେ ଯୋଉ କୋଆକ୍ୟୁଜଟା ଅଛି, କୁମନ୍ତ୍ରଣା ଦେବା ସଙ୍ଗେ ସଙ୍ଗେ ଏଠାର କିଛି ଭବିଷ୍ୟତ ନାହିଁ ବୋଲି କହୁଥାଏ। ତୋର ଏଠାରେ କିଛି ଭବିଷ୍ୟତ ନାହିଁ ବୋଲି କହୁଥାଏ। ତୋତେ ଏ ବିଷୟରେ କିଛି କରିବାକୁ ପଡିବ ବୋଲି କଣ କି ଶିକ୍ଷା ଦଉଥାଏ ଗୋଟେ ବୋଲି। ଆଚ୍ଛା, ସୁଆଣ୍ଡସୋ 1/3 ସୁଆଣ୍ଡସୋ ରାତି ପ୍ରାୟ 12ଟାରୁ 1 ହେବ କିଛି ଶବ୍ଦ ଶୁଣି ମୋର ଦ୍ୟାଟ ଇଜ ବାହାର କରିଦିଏ ସେ ଷ୍ଟେଟମେଣ୍ଟଟା, କେସ୍ ଡାଏରୀ ଅଛି ଦେଖନ୍ତୁ। କିଛି ଶବ୍ଦ ଶୁଣି ମୋର ନିଦ ଭାଙ୍ଗିବା ବେଳକୁ ଦେଖିଲି ମୋର ସ୍ୱାମୀ ଗୋଟେ ଲୁହାର ହାତୁଡ଼ି ନା କଣ ବୋଲି, ମୋର ଭାଇ ଅଞ୍ଜନ ନିରଞ୍ଜନ ଆମ ଘରକୁ ଆସିଥିବା ଝାପଲ ସୁଆଣ୍ଡକୁ ଛେଚି ଚାଲିଛନ୍ତି। ମୁଁ ଦେଖିଦେବାରୁ ସେ ମତେ ବଡ ବଡ ଆଖିରେ ଚାହିଁଲା ଓ ହାମରଟି ମୋର ଆଡେ ଉଠାଇ ଦେବାରୁ ମୁଁ ଡରି କରି ମୋର ରୁମ୍ ପାଖକୁ ପଳେଇ ଆସି ଭୟରେ ଶୋଇଲି। ଏ ବିଷୟ ଡରରେ ମୁଁ କାହାକୁ କହିନଥିଲି। ଏହାପରେ ମୋର ମା, ବାପା ଓ ଅନ୍ୟମାନେ ଉଠି ପଡିଲେ। ଏହାପରେ ପଶୁପତି ସେଠାରୁ ଦୌଡ଼ି ପଳାଇବାର ଜାଣିଲି। ଏହାପରେ ମୋର ଭାଇମାନେ କାଳେ ବଞ୍ଚିଥିବେ ଭାବି ବିଶୋଇ ଡାକ୍ତରଖାନାକୁ ନିଆଗଲା, କିନ୍ତୁ ସେଠାରେ ସେମାନେ ମରିଯାଇଥିବାର ଜଣା ପଡ଼ିବାରୁ ତାଙ୍କୁ ଫେରାଇ ଅଣାଗଲା। ସୁରୁଖୁଣାରେ କୁମନ୍ତ୍ରଣା ଯୋଗୁ ଏପରି ହତ୍ୟା ହୋଇଛି ବୋଲି ମୁଁ ଶୁଣିଲି। Did you get that? So it is almost there is no inconsistency between this 161, no contradiction 161 and statement. And statement has been recorded on the very day of lodging of the FIR. It's not that he might have stated that 8 days, but
bit by bit it
bit
is
by
correct.
bit. Here, what do you say, Mr.? You are Mr. Devasis Naik, na? What is your
Sarath
good
Pradhan.
name? Sarath Pradhan. Sarath Pradhan, acha. So what is your submission? What do you say? कौन कहବାକୁ ଚାହିଁବେ ଜଜମେଣ୍ଟ କୁ ସପୋର୍ଟ କରୁଛନ୍ତି ନା ତାଙ୍କର ପ୍ଲି ନେଇଛନ୍ତି ଗୋଟେ ଡିଫେନ୍ସ ପ୍ଲି ପାଗଳା ହେଇଯାଇଥିଲା ବୋଲି
In that light, there is no such document they have filed,
no document has been
document.
proved.
and the witnesses also
Now,
corrupt.
who else could have been the better witness to say that he was mentally deranged? Although the defense witness is saying that his brother was under treatment of one doctor in Ranchi, but there is no document to that effect.
No document.
And wife doesn't know.
Wife doesn't.
Look, please take your seat. The appellant Pasupati Bera faced trial in the court of Learned Additional Session Judge Rairangpur in city number 34 of 2007, along with one Surukuna Bera for offense punishable under section 302 by 34 of the Indian Penal Code
And
on
under section 120B.
And 120B of the Indian Penal Code on the accusation that on 1/2/2007 at in the midnight at Satsol under Bisui police station, they, in furtherance of their common intention, committed murder of Jhapal Bera, Niranjan Behera, and Anjan Behera by giving blows by crowbar and hammer, etc. And that they entered into criminal conspiracy for committing such murder. The London trial court had impugned judgment and order dated 28/7/2010, though acquitted the co-accused Sukruna Bera of all the charges. So also the appellant under section 120B of the Indian Penal Code, but found him guilty under section 302 of the Indian Penal Code and sentenced him to undergo imprisonment for life and to pay fine of rupees 20,000 in default to undergo RI for 1 year. Stop. The prosecution case, as per the first information report lodged by Srimati Kolasini Behera, bracketary PW1, on 2/3/2007 before PW16, the IIC of Bisoi Police Station. In short, is that on 1/3/2007, during the midnight, while she was sleeping, she heard some noise of opening of door, for which she got up and found that the appellant, who was her son-in-law, was standing holding a crowbar. Seeing PW1, the appellant threw the crowbar in the courtyard and ran away. The husband of PW1, that is PW2, had also seen the appellant running away. Hearing such uh, incident, PW1, so also PW2 shouted, and on suspicion, when they entered inside the house, both of them found that their two sons, Anjan Behera and Niranjan Behera, were lying in a bleeding condition. So also their nephew, Jhapal Behera, lying dead. Hearing the shout of PW1 and PW2, the neighbors came to the spot, and all of them were shocked to see the uh, bodies lying in bleeding condition. Thinking that the two sons of the informant might be surviving, they were shifted to the nearby Bisoi hospital in a vehicle, but the doctor declared both of them dead, for which the dead bodies were brought back to the house. It is further stated in the FIR that the appellant married to the daughter of PW1 and PW2, namely Puspalata, bracket PW9, since 2.5 years prior to the date of occurrence, and they were blessed with a son who was aged about 1.5 years. On 19 to 2007, there was a marriage to attend the marriage of the son of the elder brother of PW1, the appellant was invited, and he had returned to his village on 21 to 2007. During his stay, the appellant was insisting, appellant was telling others for a share in the property of his in-laws. It is further stated that on some previous occasion also, the appellant was subjecting PW9 to physical torture in connection with a share in the in-laws' properties, and the informant suspected that relating to such demand of share in the property and being misguided by the co-accused Sukruna Bera, the appellant committed the murder of the three deceased. On the basis of the written report presented by PW1, PW16 registered Bisoi PS case number 19 dated 2/3/2007 under section 302 of Indian Penal Code and took up investigation. During course of investigation, he examined the informant and other witnesses, visited the spot and prepared the spot map (Exhibit 13). And he also seized one crowbar in presence of the witnesses by its seizure list Exhibit 4, held inquest over the dead bodies and prepared the inquest report by Exhibit 2, Exhibit 3, and Exhibit 4.
Exhibit 1 is the inquest
Exhibit
report.
1. Acha, 1, 2, and 3.
1.
1, 2, and 3. He dispatched the dead body to SDH Rairangpur for post-mortem examination. He also seized the sample earth, bloodstain earth from the spot and prepared seizure list Exhibit 8. He arrested the appellant and seized his wearing apparels as per seizure list Exhibit 14. Stop. He also seized the wearing apparels of the deceased persons and sample blood of the appellants, who also his nail clippings, and prepared seizure list Exhibit 15. On the very day, that is on 2/3/2007, he handed over the investigation of the case to PW17 Sridhar Mohanto, the Circle Inspector of Police, who also visited the spot, re-examined the witnesses. Stop. The appellant, while in police custody, confessed his guilt and his statement was recorded under Section 27 of the Evidence Act, and in pursuance of such statement, the hammer, one hammer was recovered from the well in front of the house of the informant
At this,
uh,
at his instance.
at his instance, as per seizure list Exhibit 7. The appellant was forwarded to court, and afterwards the co-accused Sukruna Bera was also arrested and he was also forwarded to court. PW 17 received the PM reports and he made a query to the SDMO Rairangpur whether the injuries on the body of the deceased persons could be possible by the hammer MO1, and he received the query report. He made a prayer to made a prayer to the court to send
to send
the
incriminating material to the RFSL.
incriminating articles to the RFSL Balasore, and accordingly the same was sent, and the C report by Exhibit 17 was obtained, and after completion of investigation, charge sheet was submitted against the appellant So also the co-accused Sukruna Bera. The After submission of charge sheet, the case was committed to the Court of Session following the due procedure, where the London Trial Court framed the charges as aforesaid, since both the appellants pleaded not guilty and claimed to be tried. The sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 17 witnesses. देखिए लिख देवे. The prosecution also proved 17 documents, लिखिए, and two material objects were also proved. The defense plea of the appellant is one of denial. Appellant was one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, found that the evidence of PW9 as an eyewitness is acceptable, and it is getting corroboration from the evidence of PW1 and PW2, so also from the medical evidence. The However, the London Trial Court did not find any cogent evidence against the co-accused Sukruna, and therefore, uh, while acquitting the said co-accused of all these charges, and also the appellant of the charge under section 120B of the Indian Penal Code, found him guilty uh, under section 302 IPC. Stop. Mr. Purnachandra Behera, London Council, appearing for the appellant, submitted that the case is mainly based on the sole testimony of the eyewitness PW9, who is none else than the wife of the appellant. However, her name does not find place in the first information report as an eyewitness to the occurrence. He further submits that the PW9 has stated that she gave her statement to the she was examined by the police about 8 to 10 days after the occurrence. Therefore, the concoction of the prosecution case and setting of PW9 as an eyewitness to the occurrence cannot be ruled out. The London Council further submits that even though the wearing apparels of the appellant like Gonji and Lungi were seized, uh, and the same were sent for C examination, but no blood was found as per the C report, and therefore uh, stop. He further submits that the one defense witness, who is none else than the co-accused Sukruna Bera, has been examined as DW1, and he has stated that the appellant was suffering from mental disorder since 2003, and again he suffered mental disorder in 2006, and therefore, even if the appellant is stated to have committed the offense in view of the unsoundness of mind, is protected under section 84 of the Indian Penal Code, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Sarath Pradhan, Learned Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that merely because the name of the eyewitness PW9 is not mentioned in the first information report, which was lost by PW1, and on the soon after the occurrence, on the next day, uh, keeping in view our mental state of mind, it is not expected that he should have given all the details of the occurrence, including the fact that PW9 is an eyewitness to the occurrence. Therefore, when the evidence of PW9 has not been otherwise shaken, and there was no earthly reason for her to depose falsehood against her husband, bracketary appellant, the London trial court has rightly placed reliance on her evidence. Moreover, the evidence of PW9 is getting corroboration from the evidence of PW1 and PW2, who are also the in-laws of the petitioner, appellant, and stated about his presence soon after the occurrence with a crow holding a crowbar and running away from the spot throwing the crowbar. The London Council for the State further submitted that the three doctors who conducted post-mortem examination have also stated that each of the deceased died a homicidal death, and the weapon of offense was examined by PW 14 and PW 15. And both of them have stated that the injury sustained by the deceased Japal Bera and
Anjan and Niranjan.
ठीक है PW14 देख लीजिए ना हाँ
Could be possible.
possible. अच्छा अंजन बेहरा and Japal Bera are possible by such a hammer. The London Council further argued that the hammer was also sent for chemical examination, and the C report indicates that human blood was found on the hammer. The Land Council further submits that this hammer was recovered at the instance of the appellant from a hiding position inside the well, which has been duly proved by the witnesses, including the investigating officer. It is argued that even though PW DW1 has stated that the appellant was suffering from mental disorder, but no medical documents have been proved. Moreover, neither the wife nor the PW1 and PW2 have stated that the appellant was suffering from unsoundness of mind, and therefore the London trial court is quite justified in convicting the appellant under Section 302 IPC and sentencing him to life imprisonment. Adverting to the contention raised by the London Council for the respective parties, let us first examine whether the prosecution has successfully established that the three deceased persons met with homicidal death or not. The Niranjan, the post-mortem examination of deceased Niranjan Behra was conducted by PW13 on 2/3/2007 at SDH Hospital, and he noticed the following injury and opined like this, and um, time since death is so and so. Nothing has been the witness, the evidence of this doctor has remained unchallenged, and not a single question has been put in the cross-examination. The deceased, the dead, Anjan Behra, the postmortem examination of deceased Anjan Behra was conducted by PW14, who was the assistant surgeon, SDH Rairangpur, and he noticed this injury and like this one. So he also examined the hammer, which was sent by the police for examination and to ascertain whether the injuries on the deceased were possible by such weapon or not. And after examining the same, he has given his opinion uh, as per query report exhibit 10. Uh, Nothing has been brought out in the cross-examination to disbelieve the evidence of PW 14. The postmortem examination of the deceased Japal Bera was conducted by PW 15 on 2/3/2007 at SDH Rairangpur, and he noticed the following injuries and so on so Parigini. He also examined the weapon of offense and given the opinion that is taken. In view of the evidence of the three doctors, coupled with the post-mortem reports and the inquest reports and the evidence of other witnesses, we are of the view that the prosecution has successfully established that so and so deceased met homicidal death. Now, coming to the evidence of the sole eyewitness to the occurrence, who is none else than the wife of the appellant. She has been examined as PW 9. She stated that the occurrence, on the date of occurrence, she was sleeping uh, in one room with her child, uh, and the three deceased persons were sleeping in the next room, which was connected by a door. And at about midnight to 1 a.m., she heard some sound and got up and found that the appellant was inflicting blows by a hammer on the three deceased. When she saw uh, the the appellant, uh, he rushed towards her with wide eyes holding the hammer, for which, out of fear, she again slept on the bed. And thereafter, when thereafter she found that both the three deceased were lying in bleeding condition, and when she got up, the appellant was not there. Uh, in the cross-examination, she has stated that the appellant was her second husband, and uh, police and her father bracketed PW2 and mother PW1 came to the spot of occurrence after about 10 to 15 minutes of the occurrence, and many villagers had also gathered there. She stated that she told about the occurrence to her parents after 3 to 4 days, and uh, uh, and to the police about 8 to 10 days after the occurrence of the occurrence. However, she stated that the electricity light was there in the house, and the room in which she was sleeping and the room in which the three deceased persons were sleeping were lighted by electricity. Uh, she stated that the police arrested the appellant on the next day of occurrence and she disclosed to the villagers after telling the same to her parents. Uh, the learning counsel for the appellant argued that since the name of the PW9 doesn't find place in the first information report and she did not disclose about the incident immediately to her before her parents, and according to her own version she disclosed about the occurrence 8 to 10 days after. It cannot be said that she is a truthful witness, and there is every possibility that she has been set off as an eyewitness to the occurrence afterwards. However, we found that from the case diary that the statement of PW9 was recorded on the date uh, when on 2/3/2007 when the first information report was lost. Moreover, the missing of the name of uh, PW9 in the first information report cannot be a factor to disbelief or evidence. It cannot be lost sight of the fact that PW1 had lost two of her sons and her nephew when she lost the first information report, and she would be in a perturbed state of mind, and at that point of time it was not expected of her to give all the details of the occurrence and who are the eyewitnesses to the occurrence uh, in the first information report. Mere omission of the name of PW9 in the FIR, in our humble view, is not a ground to disbelieve the evidence of PW9 as an eyewitness to the occurrence, whose evidence has not at all been shaken in the cross examination, and moreover, she being the wife of the appellant is not likely to tell falsehood against the appellant in a charge of murder. The evidence of PW9 is getting corroboration from the evidence of PW1 and PW2. PW1, the informant, is the mother-in-law of the appellant, and she has stated that on the occurrence night, she was sleeping with her husband, bracket PW2, in one room, and in another room, her two sons, Anjan and Niranjan, so also the nephew, Japal, were sleeping, and appellant and his wife were sleeping in another room, that is the entrance uh, of which the three deceased were sleeping. And at about midnight, the she heard some sound, woke up, and um, when she, along with her husband, came out, they found that the appellant was holding a crowbar, and when they called him, he ran away throwing the crowbar. And on suspicion, she, along with her husband, entered inside the room where they found where their two sons and nephew were sleeping, and found uh, all the two sons and the nephew were in serious condition with profuse bleeding. And at that time, the nephew was lying dead, and therefore they shouted at the spot, and hearing their shout, uh, the neighbors came, and hoping that their two sons would be alive, shifted them to Bisoi Hospital. but the doctor found them dead. This PW1, the PW1 has further stated that about 1 year prior to the occurrence, the appellant was staying in their house, and during his stay, he was insisting his wife, bracketly PW9, to persuade uh, PW2 to get the properties in his name. And the appellant, Sukruna, uh, was also persuading the appellant uh, to get the properties of her husband in his name. Uh, the evidence of this witness has not been second in the cross examination, and uh, uh, her evidence is getting corroboration from the evidence of her husband, bracketed PW2, who has also stated that he found the appellant was running away, throwing a crowbar, when he, along with his wife, bracketed PW1, came out hearing some sound. He has also stated that the appellant was staying in their house for about 1 year since the date of occurrence, and demanding uh, 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 share from the properties. Uh, Stop. And he has further stated that the brother of the appellant was also persuading him to grab the properties. Stop. Therefore, Asha, a specific suggestion has been given to the PW2 that the appellant was suffering from unsoundness of mind, for which he, along with his wife, bracketed PW2, were treating him at Ranchi, but he has denied such suggestion given by the London Defense Council. The evidence of the eyewitness PW9 is not only getting corroboration from the evidence of the these two witnesses, that is PW1 and 2, but also from the evidence of the three doctors who conducted post-mortem examination uh, and proved their reports. The submission of the London Council for the petitioner, the appellant, that the appellant was suffering from unsoundness of mind, uh, and the evidence to that effect has been given by the DW1, who was an co-accused in this case. We are of the view that though the said witness has stated that the appellant was suffering from mental disorder in the year 2003, and again he suffered from mental disorder in the year 2006, uh, and he was not free from the mental disorder and was being treated by one Sailendra Kumar at Ranchi, and that the doctor was prescribing some medicines, but no medical document has been produced in support of such treatment to substantiate the unsounded the plea of insanity. Uh, the witness DW1 admits that he has not produced any document before the police. Stop. Section 84 of the Indian Penal Code states that which deals with the act of a person of unsound mind, states that nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Stop. The law is well settled that there is a difference between medical insanity and legal insanity. An accused who seeks exemption from liability under Section 84 has to prove legal insanity and not medical insanity. The burden of proof that the accused was of unsound mind and as a result thereof he was incapable of knowing the nature and consequence of his acts is on the accused. In view of Section 105 of the Indian Evidence Act. To establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the accused was laboring under such a defect of reason, from disease of mind, as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing what was wrong or contrary to law. The crucial point of time at which unsoundness of mind should be established is the time when the crime was actually committed. The mere fact that on former occasions the accused had occasionally subject to insane delusion or has suffered from derangement of mind, or that subsequently he had at times behaved like a mentally deficient person is per se insufficient to bring his case within the exemption. In order to ascertain whether the accused was insane at the time of commission of offense, it may be relevant to consider the state of such person's mind immediately preceding as well as subsequent to the commission of offense. In the case in hand, the statement of the eyewitness PW9 indicates that when he saw the occurrence and the accused became aware of it, the accused rushed towards the her with wide eyes holding the hammer. Not only that, when the accused was seen with the crowbar by PW1 and 2, he threw the crowbar and ran away from the spot. Evidence is also available on record that the hammer was concealed by the accused inside the well. All these things indicates that the accused was not in unsoundness of mind at the time of occurrence. Rather, he was quite conscious of what he was doing, and the evidence on record is also there that he has a motive behind commission of the crime, as he was expecting a share from the properties of his in-law. In view of the foregoing discussions, we are of the view that the prosecution through the evidence of PW9, PW1 and 2, coupled with the medical evidence and the evidence of the IO was stated that at the instance of the petitioner, the weapon was recovered from the whale. It has been successfully proved that charge under Section 302 IPC has been successfully proved. Therefore, there is no infirmity in the judgment. Accordingly, the conviction of the appellant under Section 302 IPC is upheld. In the result, the JCRLA stands dismissed. The put a note of appreciation on this one. So whether he's on bail or he's yeah.
Not on bail.
Excuse me. Item 17. Yesterday also I argued for mentioning for the item 17, 17 and 18, man.
What is your name?
On behalf of Mr. Anurag Mahapatra.
No, Anurag Mahapatra has been appointed by the legal aid.
Legal aid, man.
So how can you he is to argue the matter? It's not that you will argue the matter. If he is not there, we'll engage somebody else. As for the list provided, you cannot argue the matter.
So I will inform him and say he will come and argue tomorrow.
He will come and argue.
Yes.
Are you sure? Because
Yes, I will inform.
Otherwise, we'll engage somebody else.
Yes, my lord. I will inform so he will come. Item is 17 and 18.
17, 18 में जो order था वो है चला बेटा लिखी हुई नहीं खाली कोई समझा आपको
Item 47 है वाला when I did
we'll see the tomorrow we'll see
7 years ago.